Welcome to GW Law School's 2022 JB and Maurice C. Shapiro Environmental Law Symposium. I'm Rob Glicksman, a faculty member at GW Law who specializes in environmental, natural resources, and administrative law. This afternoon's program is titled EPA's Regulatory Jurisdiction on Trial. The focus of today's discussion will be on two environmental law cases on which the Supreme Court has granted certiorari. One of those has already been argued before the court, and a decision is expected at the end of this term. The second case will be argued in the fall. The cases arise under two foundational statutes that arguably have provided EPA with its most substantial authority to protect the environment. The Clean Air Act of 1970, as last amended in 1990, and the Clean Water Act of 1972, as last amended in 1987. The Clean Air Act case is West Virginia versus EPA, which involves EPA's authority to regulate greenhouse gas emissions from power plants that burn coal or natural gas to generate electricity. The Clean Water Act case is Sackett versus EPA, which is the latest salvo in a decades-long battle over the authority of the Army Corps of Engineers and EPA to regulate construction and related activities that affect wetlands. These cases are potentially among the most important environmental cases the Supreme Court has ever decided. The court's resolution of the issues raised in West Virginia could confirm or greatly restrict EPA's authority to adopt regulations that restrict emissions that contribute to climate change. Its disposition of Sackett could affect not only the bounds of federal regulatory authority over wetlands, but also the scope of EPA's authority under the Clean Water Act to restrict industrial and municipal pollutant discharges into the nation's surface waters. One of the interesting things about these cases is that the court's decisions to grant cert in both cases was somewhat surprising. In both cases, the court arguably reached out to decide cases in a regulatory vacuum. Some have construed the court's actions as signals that it's prepared to significantly constrain EPA's regulatory authority. And any such constraints may affect not only the scope of EPA's authority under its other organic statutes, but also federal regulatory authority more generally. In other words, these cases may provide barometers for the Supreme Court's appetite to significantly reform, if not revolutionize, federal administrative law. To flesh out these issues today, we have a stellar cast of experts in environmental and administrative law. Our first speaker will be Richard Lazarus, who's the Howard and Katherine Aibel Professor of Law at Harvard Law School. When Richard discusses developments at the Supreme Court, he knows whereof he speaks. He has represented clients, including the United States, in at least 40 Supreme Court cases, and has presented oral arguments in at least 14 of those cases. Among Richard's many publications are his iconic history of U.S. environmental law, 2004 University of Chicago Press book, The Making of Environmental Law. Also his more recent book, The Rule of Five, on Massachusetts versus EPA, the Supreme Court's first climate change case. Richard was also the principal author of the report to the President on the National Commission on the BP Deepwater Horizon oil spill, an offshore drilling commission for which he was the executive director. I'll introduce all the speakers now. Our second speaker will be Jonathan Adler, the inaugural Johan Verheij Memorial Professor of Law at the Case Western University School of Law. Jonathan is also the founder and director of the Coleman P. Burke Center for Environmental Law at Case Western. He's a contributing editor to National Review Online and a regular contributor to the popular legal blog, The Volokh Conspiracy. Among his publications are his 2016 Oxford University Press book, Business and the Roberts Court. Our third speaker will be Robin Craig, who holds the Robert C. Packard Trustee Chair in Law at the University of Southern California Gould School of Law. Robin specializes in all things water, including the relationship between climate change and water, making her the perfect person to explore West Virginia and Sackett. Robin was elected to membership in the American Law Institute in 2015 and the American College of Environmental Lawyers in 2019. She was also appointed to the International Union for the Conservation of Nature's World Commission on environmental law. Robin is a prolific scholar whose book, Re-Envisioning the Anthropocene Ocean, is forthcoming from the University of Utah Press. After we hear from these three speakers, we will have a roundtable discussion that will include contributions from me and my colleague at GW Law, Richard Pierce. Dick, as he's known to me and others, is the Lyle T. Professor of Law at GW. He's perhaps the nation's foremost expert on administrative law, but his areas of expertise also encompass energy law and policy and economic analysis of law. Dick's administrative law treatise, now in its 6th edition, is the current version of the work on which Dick once collaborated with Kenneth Culp Davis. He's published about 20 more books and well over 100 law review articles on administrative law, government regulation, and the effects of government intervention on the performance of markets. His work has been cited by the Supreme Court more than a dozen times. For those in the audience, please feel free to submit any questions you have using the chat function. I will tend to take questions in the nature of clarifications at the end of each speaker's presentation. I may save broader questions for the roundtable portion of the program. With that, I'm finished with my introductory remarks, and I'll turn the program over to Professor Lazarus.
Thanks, Rob. I'm just going to take just a moment to share a screen, and I'll be right there. Terrific. Again, Rob, thanks so much for that introduction, and more broadly, thank you, GW, for inviting me to participate in this terrific program. George Washington has a fabulous environmental law program. It long has had that program, one of the first in the country, really. A little known fact is actually I taught as an adjunct professor at the at George Washington University. I taught in 1987, I think, so 35 years ago. I'm also really pleased to be joined by two terrific colleagues here. Jonathan Adler and Robin Craig, good friends, and of course, Dick Pierce, who's, as Rob said, really one of the foremost scholars of the country on administrative law, among many other topics. By tradition, the Supreme Court is often referred by the name of the Chief Justice. The Warren Court became the Burger Court, that became the Rehnquist Court, and then more recently became the Roberts Court. Such naming reflects the central role played by the Chief Justice in the court's operations and its decision-making. After all, unlike any of the associate justices, the Chief Justice's title is different. It's Chief Justice of the United States. The others are referred to, and you look at their formal commissions they receive, as justices of the Supreme Court. And that's because the chief presides over the entire third branch, unlike the others. He establishes the committees of federal judges who serve on establish the federal rules of civil procedure, appellate procedure, criminal procedure. He assigns on his own the lower court judges to serve on special courts, such as the Foreign Intelligence Surveillance Act. Even more significantly, the chief, of course, has no more votes than any of the other on the bench, but by tradition, he's considered the most senior justice on the court, even if other justices have served much longer time, which is meant as a practical matter, the chief plays a dominant role in the all-important role of assigning opinions and the writing the majority opinions of the court. At age 67, Chief Roberts is currently the 5th longest serving Chief Justice, and by next October, he'll surpass Chief Justice Warren Burger in length of tenure, and then he'll become the 4th longest service chief in the nation's history, still at the age of 67. However, to underscore the outside influence of a justice other than the chief, commentators will often refer to the court by the name of that justice. For instance, after Justice Sandra Day O'Connor retired, commentators frequently referred to the Kennedy Court in recognition of how frequently Kennedy controlled the majority on the bench. But when Justice Kennedy later retired, and Roberts was both the Chief Justice and the controlling vote in most divided cases, the headliners quickly boasted that now the court was truly the Roberts Court in all ways. That headline, though, as we know, proved short-lived. Only a few months later, Justice Ruth Bader Ginsburg passed away. Justice Amy Coney Barrett took her seat on the bench. And there were suddenly 5 more reliably conservative justices to the right of the chief. And that quickly, he went from one of the most powerful chief justices in modern history to arguably one of the most isolated in recent memory, at least to the extent that he chooses to split from the other 5 and loses accordingly his all-important opinion assignment authority. It would be a mistake, however, I think, to refer to the newly constituted court as the Kavanaugh Court, as if you have done, presumably on the theory that Kavanaugh is the most moderate of the 5 very conservative justices. I think far more interestingly, the more accurate moniker would be the Scalia Court. Although Justice Scalia died over 6 years ago, without obvious historical parallel, in many ways, Justice Scalia is more influential in the court today, I think, than at any time he was alive and on the court. Although they arise under 2 very different laws and raise 2 very different legal issues, there are 2 potentially monumentally important cases, environmental cases, now pending before the Supreme Court, we think will underscore Justice Scalia's continuing and increasing influence on the court's rulings. The first, West Virginia v. EPA, rise in the Clean Air Act and concerns the scope of EPA's authority to address the most pressing environmental issue of our time, climate change. The second, Sackett versus EPA, arises in the Clean Water Act and concerns, as Rob said, the geographic scope of that act. West Virginia was argued this past February, just a few weeks ago, and should be decided by the end of June, when the court traditionally recesses for the summer. The Sackett case should be argued next October, likely on or within a day or so of the first Monday in October, when the court commences its October term 2022. Based on the opinions Justice Scalia wrote while still on the court, what the justice views would have been on the question presented in these cases are quite clear. Justice Scalia was, let's just say, not one to mince words, and he authored opinions that leave, I think, no doubt how he would have voted in these cases. Against EPA's assertion of expansive jurisdiction over existing coal-fired power plants at issue in the West Virginia Coal Clean Air Act case, and against an expansive view of the geographical reach of the Clean Water Act in Sackett. And since his passing, 3 justices joined the court during the Trump administration, each making clear their admiration of Justice Scalia and the desire to emulate his jurisprudence in their own voting. The only real debate between the 2 during the successive confirmations has been which one is more loyal to Scalia's example. My talk today is divided into 3 parts. Part 1 describes the dominant themes of Justice Scalia's views in environmental cases and why those views are likely to be more influential in the foreseeable future than they were while he was on the court. Part 2 reviews both the West Virginia and Sackett cases and explains both why and how the court's rulings in both cases are likely to reflect Justice Scalia's views. And finally, part 3 concludes by suggesting that Scalia's legacy will, if not somehow checked by Congress, be the equivalent of a wrecking crew, risking the destruction of a regime of federal environmental protection that has constituted one of this nation's greatest success stories over the past 50 years in safeguarding public health and welfare. All right, so first, Justice Scalia and environmental law. Given the utter lack of any interest in Scalia's views on environmental law during his 1986 Senate confirmation hearings, one might understandably assume his views were then largely unknown. He was a stealth nominee, but that's not true, just the opposite. Scalia's views were both well-known and openly hostile to aggressive environmental protection requirements. The reason for complete silence was apparently instead that no one cared, even though Scalia's views portended a sea change in judicial attitudes toward the role of the federal judiciary in environmental law. 50 years ago, the nation's courts could be widely credited for the enormously positive and constructive role they play in their early rulings, helping the nation's environmental laws during the 70s, 60s really, 70s and 80s, by embracing new expansive theories for pollution control law and based on seemingly ancient laws, like the Rivers and Harbors Act of 1899 and the Organic Act, the Forestry Law of 1897. The courts then would construe old statutory text to control modern environmental problems, like massive industrial pollution of nation waters, rely on the Refuse Act to find those discharges unlawful, or massive clear cutting of the national forest, like Monongahela National Forest, finding the Organic Act 1897 sufficient congressional intent to say that practice clear cutting was now unlawful. They ruled that old texts made those modern practices unlawful. They were unbound by whether the Congress that passed those laws in 1897 or 1899 specifically contemplated their application of practices not possibly known at the time of their enactment. They decided instead to make it up to Congress. If they wanted to change the law, they could do so. They changed the default. And Congress did just that. Partly in response to law, they passed the Federal Water Pollution Control Act in 1972. And possibly in response to the Monongahela case, they passed the Forest Land Management Act in 1976. Indeed, courts not only prompted, but welcomed them these new laws. Many judges saw it as a judicial function to safeguard them. No judge better illustrates that judicial perspective of 50 years ago than Scalia Wright of the DC Circuit. Judge Wright came to DC Circuit from the District Court of New Orleans. He was basically exiled DC Circuit because of his very strong views on civil rights laws. We promoted integration of the schools there, had crosses burned on his lawn, and Democratic senators really asked President Kennedy to get him out of the South and put him on the DC Circuit. And once he's there, Wright saw the connection between civil rights and environmental law, the need to protect unrepresented, those less politically and economically powerful, like the future generations. His judicial philosophy made famous in the Calvert-Cliffs decision in 1971, one of the nation's most famous environmental law judicial opinions, a ruling that made NEPA a transformative law. The first paragraph of Judge Wright's opinion says it all. Right? These cases are the beginning of what promised being a flood of new litigation. Normally one thinks of a flood of litigation as a threat, but to Judge Wright, it was instead a promise. He described the court's role, right? It was to make sure that this promised legislation will become a reality. The judicial duty was to make sure these things would not be lost or misdirected in the vast hallways of the federal bureaucracy. That was, he put, our duty of courts. For Wright and other judges at that time, there was almost a quasi-constitutional dimension to environmental law. While courts never endorsed the notion of a federal constitutional right to environmental protection, they clearly treated environmental protection concerns as entitled to special judicial protection. That attitude spawned expanded judicial access to environmental plaintiff citizen suits, expansive rulings favoring strong environmental protections, establishing the PSD program, Prevention of Deterioration of the Clean Air Act, and upholding strict joint and several liability in the Superfund law in the 1980s. In late 1985, the Supreme Court ruled 9-0 without dissent in the Riverside Bayview case in favor of EPA and the Court's expansive view of the meaning of navigable waters and the Clean Water Act, far beyond the literal meaning as needed to protect aquatic systems. Justice Scalia, though, joined the court, however, only 10 months later, and he championed a very different view of the judicial role in environmental law. As previously mentioned, during his confirmation hearing, no attention was paid to then DC Circuit Judge's views, Scalia's views on environmental law. But that was not because of the absence of a record. Justice Scalia was in many respects the anti-Scalia Wright, and proud of it. Here is what he wrote about Wright's words in Calvert-Cliffs, what Scalia wrote in 1983, before he went on the High Court in September of 1986. He argued for heightened judicial barriers to environmental protection lawsuits. He didn't just criticize Wright's announcement of the judicial role for protecting the environment, he mocked Judge Wright. He decried the judiciary's long love affair with environmental litigation. He acknowledged that his view would mean that those policies would be lost in the vast hallways. And he said, and that's a good thing too. Justice Scalia was confirmed by a vote of 98-0. You can go through the hearings, you can go through the reports. There's not one single mention of environmental law in any of those documents. And once on the court, he basically reversed the relationship between the Constitution and law and the environment in dialogue. Had been before whether it was a constitutional right to environmental protection, and now became whether environmental protection law was itself constitutional. Before, it had been whether federal agencies and underreaching had failed to exercise their full statutory authority as contemplated by Congress, now became whether federal agencies were overreaching, claiming more authority than they in fact possessed, implicating separation of powers concerns. Justice Scalia brought to the Supreme Court a new skepticism of wisdom of tough environmental laws, and he channelized that skepticism into authoring and joining court rulings that cut back on the suit of environmental protection laws and the kind of vigorous judicial enforcement of their terms promised by Judge Wright and Calvert Cliffs. In Nolan and Lucas, two takings cases, he authored opinion for the court that held that environmental protection laws violated the Takings Clause. In Lujan 1 and Lujan 2, and later Summers v. Earth Island Institute, he authored opinion for the court that environmental plaintiffs lacked Article 3 standing to enforce federal environmental protection requirements. In Utility Air Regulatory Group, Michigan versus the EPA, Justice Scalia authored opinions limiting EPA's authority to regulate greenhouse gases and hazardous pollutants under the Clean Air Act. And Solid Waste Agency of Northern Cook County, or PONS, the United States, he wrote opinions for the court and for a plurality that narrowed the view of authority of EPA and the court to have jurisdiction over waters of the United States. This was a far cry from the unanimous ruling of the Riverside Bayview Court, unanimous, just 10 months before Justice Scalia took the bench. Yet, notwithstanding his clear impact on environmental law in over 30 years on the court, it's no less clear he was ultimately limited during those 3 decades. Even though the court can be fairly characterized as dominated by conservative justices during his term, Scalia often found himself in dissent in federal environmental cases and cases in which the majority rejected his views. In regulatory cases, taking cases, he was relegated to dissent. He not only failed to garner a majority in the Lucas case, his stubbornness and technical provision style alienated other conservative justices. Yes, he got the opinion for the court, but he lost Kennedy's vote in Lucas. And then he attacked Justice O'Connor for her views in the Palo Zolo case a few years later. And ultimately, not coincidentally, he ended up on the losing side in the Taos Sierra Preservation Council case, with both O'Connor and Kennedy joining Stevens' majority opinion. The same trend happened on Article 3 standing. In Lujan 2, he refused to compromise and qualify his opinion in ways, and he lost Justice Kennedy's vote for part of it. And Justice Sandra Day O'Connor dissented completely. Here again, Scalia was ultimately in the dissent in 2 blockbuster standing cases. Friends of the Earth v. Laidlaw, he lost Rehnquist, O'Connor, and Kennedy. And in Massachusetts versus the EPA, he lost Kennedy. And of course, his dissent in Massachusetts EPA failed to cut back on EPA's authority to regulate greenhouse gases. And in EME Homer, failed to limit EPA's regulatory authority to address interstate air pollution. He failed to track the votes in that case, either Chief Justice Roberts or Justice Kennedy. And in Rapanos versus the United States, he lost his majority opinion. He was instead left with a plurality. Justice Kennedy declined to his joint opinion, leaving Scalia with 4 votes, no more votes than Justice Stevens got in his dissent. And Kennedy's controlling opinion, I'll describe later, was far closer to Stevens' dissent than to Stevens' plurality. What Scalia failed to accomplish while still alive, and as a member of the court, he may well succeed in accomplishing post-mortem in his name. If the court today were to decide ab initio all those cases in which Scalia's position did not prevail, I harbor little doubt they would instead be decided consistent with his views. In campaigning for the presidency, candidate Donald Trump promised to nominate justices in the mold of Justice Scalia, and he did just that 3 times. If the court today were to decide those cases I just mentioned, where he had dissented or failed to have a majority, I think there's a good reason to believe the court would find a taking in Taos Sierra. I think they'd find no standing in Friends of the Earth v. Laidlaw or in Mass versus the EPA. I think they'd find no regulatory authority to regulate greenhouse gases under the Clean Act under mass versus the EPA. I think they would have found that the EPA didn't have the authority it thought it did for the cross-state interstate rule in the E&E Homer case. And the Rapanos case would not have been a 4-justice plurality. It would be a 6-justice majority. And that takes me to the next part of my talk. The 2 environmental law cases now pending before the Supreme Court that will soon test the proposition I proposed. Now, anomaly at issue in the West Virginia case is the validity of Trump's repeal of the Obama administration's Clean Power Plan. And they base that on the plain meaning of the Clean Air Act. No effort to seek Chevron deference under Step 2, a plain meaning repeal. So what is the Clean Power Plan? Well, and on what legal basis did EPA promulgate it, and what did it seek to accomplish? The target of the Clean Power Plan are existing power plants, one of the largest sources of greenhouse gases in the country. EPA claimed authority to promulgate the Clean Power Plan under Section 111D of the statute. And here's the relevant language. The language allows the administrator to prescribe regulations under which each state submit administrator plan, which establishes standards of performance for any existing source for any air pollutant. The existing sources of air pollutants are the existing power plants, coal-fired power plants in particular. The pollutant, of course, are greenhouse gases. Like most environmental law, the important provisions are then defined. And Section 111A defines standard performance. It means the standard of emissions achievable through the application of the best system emission reduction the administrator determines has been adequately demonstrated. So that is a tech-based standard. Now, in the past, what EPA has done for tech-based standards and other parts of the statute is look for things that can happen on the site of the facility itself, like a power plant. So for past tech-based standards applicable to power plants, EPA has said you can put scrubbers right there. Those scrubbers will take out the sulfur dioxide, among other things. You can put precipitators there, electrostatic precipitators, right there, and they can take out the particulate matter. And you can make your plant much more efficient, so you burn less coal to produce electricity. What all those sort of bases of regulation had in common was they all were at the facility itself. If you go to a power plant, actually those extra things often are larger than the combustion part of the plant. They cost hundreds of millions of dollars. They are very effective. The Clean Power Plan is different, though. The Clean Power Plan looks at the plant, and then it first did something very traditional. They said, how can you be more efficient? How can you burn less fuel, whether it's coal or natural gas, and produce the same amount of electricity? But then it did something different. It said, and to what extent can we shift the production of electricity from at your plant to other sources on the grid, other sources on the nation's electricity grid? To what extent is there underutilized capacity for natural gas facilities, some of which you may own or not? And to what extent can we shift it to renewable, like wind, like solar, or hydroelectric? So it's the idea of generation shifting. To what extent can we produce the same amount of electricity, but use the coal-fired plants less? If you go back to the statute, it all depends upon this. What EPA is basically saying is the best system of emission reduction, as construed by the agency, all turns on the word system. And for EPA, that word system is broad and capacious enough to basically refer to the nation's electricity grid. The system is the grid. It's not just the plant by itself. Technology which did not exist in the 1970s now gloriously exists. And so you look at the best system emission reduction, look at the whole grid. And in support of that, EPA said, and this is what regulated utilities do all the time. They constantly shift generation among sources on the grid, often to meet pollution control requirements at the cheapest cost. All we do now, which is different, is base the pollution control requirement in the first instance on that. The Obama administration expended enormous resources in crafting this ambitious tool to reduce greenhouse gas emissions by a projected 32% by 2030. And then they fought tooth and nail to defend its validity in court. But notice again, I say it's the validity of the Trump repeal is nominally at issue in West Virginia. I said nominally deliberately, and that's because it's already a foregone conclusion that the court will uphold the Trump repeal by a lopsided vote. Indeed, it was so obvious the Clean Power Plan could not survive Supreme Court review that after the Trump administration placed 3 new justices on the court, the Biden EPA, within 3 weeks of taking office, threw the Clean Power Plan under the bus, announced it was dead and buried, and tried to use that elimination to avoid any possibility the Supreme Court would grant review. That was an extraordinary thing to do. After all, on January 19th, the day before President Biden took the oath of office, the DC Circuit had ruled the Trump repeal was invalid. In a normal course, that would have led to an automatic revival of the Clean Power Plan as soon as the Biden administration began. One might think that's a great gift. They wouldn't have to repromulgate it. They wouldn't have to worry about undoing the repeal. They'd be back on track with the plan that many of the same people now in the Biden administration had fought for during the Obama administration. But what they knew, what the Biden people knew, is this was no gift. This was, in fact, a disaster. Why? Because while the Obama administration was willing to defend the Clean Power Plan before the Supreme Court in 2016 and thereafter, especially if Merrick Garland replaced Scalia and Hillary Clinton was elected president, neither had happened. And the court today is not the court in 2016. It is instead now Scalia's court. So the Biden EPA unilaterally surrendered the Clean Power Plan within just like 2 weeks of taking office. They filed a motion with the DC Circuit and said, don't do it. Don't revive the Clean Power Plan. Stay your mandate. We don't want to come back to life. We want you to end it. And we're going to go back. We're not going to redo the Clean Power Plan. So please don't put it back to life. And the DC Circuit did just that. And no environmental group complained. No one. Why? Because they could count to 6-2. They could see what happened if this case went to the Supreme Court. Shockingly, however, the Supreme Court granted review anyway. The court granted review. And the SG, not overlooking, but basically giving no weight to the SG's opposition. The SG's opposition to the cert petition, you can see there, was saying, look what we did. We killed the case. There's no reason to take it. There's no existing regulation at all of these coal-fired power plants for greenhouse gas. There's none under anything. There's no case here. And the court, right, took the case anyway. So now the only real question is how the Biden administration will lose the case before the Supreme Court. In my world of Supreme Court advocacy, it is not unusual for respondents to know they are losing the case. And the challenge of the counsel respondent is to try to achieve a soft landing rather than a hard landing. The latter admits your loss, allows your client here EPA with plenty of other tools on remand to get the job done. But after oral argument on February 28th, I think the only question is how hard the landing will be. Here are the landings from softest to hardest. So the softest landing, which the Biden administration was trying to get, was get the court to dismiss the writ on the ground the petitioners lack standing, the case is moot, and to vacate the DC Circuit opinion on that ground. That would have been a big win if they could get it. But at a price, they can only get that win because they basically got rid of the Clean Power Plan. Remember, this was a very important plan to the Obama administration. They're willing to bury it and say it's dead to not get this case heard on the merits. So that would have been a softest landing, but one exacted at a price. A soft landing would be for the court to conclude that the Trump appeal was okay based on the plain meaning of Section 111, or as we say in the US Code, 7411, because the term system doesn't go beyond the fence line. That would be a loss, but a fairly soft loss in context, because EPA could base further emissions limitations on very stringent controls within the fence line, assumptions that states and utilities could choose to meet those strict ones with outside the fence line measures. A medium way for EPA to lose this case, where the court rules on the ground the EPA lacks authority under Section 111 to promulgate binding emission limitations on the states. They can only do non-binding guidance for the states. That would be a loss, a significant loss, but one which would be limited to this particular provision of Section 111D of the statute. Here's the hard landing. The court could say, we don't have to look just at the plain meaning. We're going to rely in the first instance on the major question doctrine. And we're going to rule that EPA lacks the authority because the Clean Power Plan involves the kind of outside the fence line measures that to do would be basically of vast economic political significance and no evidence, clear congressional intent, give EPA such transformative authority. The impact of that rule could be potentially devastating. The administrative agency, including EPA, not just for the Clean Power Plan, they're willing to give that up for all kinds of federal environmental statutes, all kinds of federal statutes, which rely historically on broad and capacious language and not evidence of specific congressional contemplation. The hardest fall of all, the court actually went so far as to say it violates the non-delegation doctrine. That even if Congress provides specific criteria for the agency to guide their rulemaking, that still violates the non-delegation doctrine. The decisions always have to be made by Congress in the first instance. I expect the most likely hard landing is the one that Justice Scalia would have favored, as forecast by his own opinion in the Utility Air Regulatory Group case a few years before he died. The court will rely on the major question doctrine, and they'll conclude the Trump repeal was valid, not based on the narrow ground that was contradicted by the plain meaning of the relevant Clean Air statutory language, but instead on the potentially far more sweeping ground that under the so-called major question doctrine, to sustain such an ambitious rulemaking requires statutory language that demonstrates that Congress specifically contemplated such a rulemaking. It's the very broad ruling I think Justice Scalia would have favored. After all, he tried unsuccessfully in Massachusetts EPA to rely on the major question doctrine to get the court to say there was no authority to regulate greenhouse gas emissions. He strategically brought the major question doctrine back to life in URAG. Scalia's opinion for the court, as he acknowledged at the time in URAG, was nominally a loss for EPA, but it claimed this egg waiting to be hatched in a future case. There would be a major loss for EPA. The opinion in URAG even seemed to anticipate the Clean Power Plan on its terms and what it was seeking to do, even if it was only a proposed rule at that point. Nor at that time was there anything subtle about what Scalia was doing. He was placing a bullseye on the Clean Power Plan, even as proposed rule. In the West Virginia oral argument case last month, it was clear to me that Scalia's egg had hatched. Essentially, all 6 conservative justices expounded on the major question doctrine. The justices and the advocates exclusively referred to the doctrine 58 times. And Justice Kavanaugh twice announced that Scalia's test in URAG was the controlling test to be applied in the West Virginia case. I cannot know, of course, the precise wording of the opinion of the court to be announced by the end of June, as the court recesses for the summer. Well, I think anyone who has followed the case closely could do a pretty good job of writing that opinion ahead of time. It'll be the hard landing. It won't be the hardest. But what I do know is whatever its precise wording, Justice Scalia's fingerprints will be all over it. Sackett versus EPA. With Sackett, though, even less speculation is required. What the court will rule and Scalia's likely influence, because you already have in effect Scalia's draft opinion for the court. At issue in Sackett is a Clean Water Act issue as big as the Clean Act issue in West Virginia. Sackett concerns the geographic scope of the Clean Water Act and its bar on discharges in navigable waters of the United States absent a permit. For much of the Clean Water Act's history, consistent with its legislative history, the long-settled view was the term navigable waters applied far beyond traditional notions of navigable waters. Extended to tributaries of those waters, it extended to wetlands and other waters that had significant hydrologic nexus to navigable waters, but not were themselves remotely navigable. As described by the unanimous court in Riverside Bayview, less than a year before Scalia joined the court, achievement of congressional objectives to protect the quality of the nation's waters support a more functional than strictly textual interpretation of the statute, because otherwise, EPA and the Corps could not effectively protect the nation's waters, given their hydrologic connectivity. You had to look beyond. You had to actually take a real functional look at the waters. In 2006, though, right after Chief Justice Roberts and Justice Alito joined the court, he pushed the court parallelly to the right as soon as Gould left. Scalia announced in Rapanos a dramatically reduced vision of the geographic scope of the Water Act. We're relying heavily, as he would do, on a dictionary definition of the word water. Scalia's opinion openly declared that waters consisted, quote, only of those relatively permanent, standing, or continuous flowing bodies of water, forming geographic features like oceans, rivers, and lakes. He potentially removed from the Act's coverage waters that flow intermittently or ephemerally, and much of the nation's wetlands and other waters that would likely fail Scalia's textual test, but everyone knows, as a scientific matter, are practically important for protection of water quality. If you can't control discharge of those waters, you can't control the water quality in the waters in which they flow. Justice Scalia, as I mentioned before, did not join his opinion. Instead, he dramatically departed from it. He left Scalia with a plurality boasted no more than 4 votes, the same as Justice Stevens' dissent, and a very, very different test. And a test which in theory would allow EPA to do everything it had wanted to do before, and the Corps, but just based on a more grounded, appropriately more grounded series of scientific and technological studies. The Sackett case, however, allows the court to revisit the Rapanos issue with a court that no longer includes Justice Kennedy, but it has 3 justices who joined Rapanos' opinion, now joined by 3 new justices who made clear their loyalty to Scalia's legacy. Nor were the Sackett petitioners at all shy about making clear what they were trying to do. Petition characterized the adverse lower court ruling as relying on Justice Kennedy's controlling concurring opinion, and asked to revisit that ruling to adopt Justice Scalia's plurality view as instead the controlling rule. Petition never once mentioned that Kennedy was on the court, and never once mentioned there were 3 new justices on the court. They didn't have to. It was clear that petitioners knew how to count to 6, not to 5. The court's mere granting the review leaves little doubt where the justices are headed, I think at least presumptively. When the petition is filed in a case like this, like West Virginia, it had all the trappings of routine cert denial, as Rob sort of hinted in his introduction. There was no circuit conflict, and here is in West Virginia, there were strong prudential reasons for the court not to hear the case at all. Like in West Virginia, the new administration opposed certiorari. They said, pointed out correctly, there's no circuit conflict on this. Everyone agrees that Kennedy's opinion is the controlling opinion. And what's more, we've recently announced there's going to be a new rule in this area. We're not returning to the regulatory scheme of the Obama administration that relied on Kennedy's concurrence. We've actually put out a notice, a formal federation of a new rule, that they'd be working on a new rule, not a proposal, but a new rule. And they asked the court to delay until it had a chance, the new administration had a chance, like in West Virginia, to come up with a new rule, and the court could then address that. But as in West Virginia, the court didn't, as it regularly, routinely had done in the past, just wait for the new rule to come out. They agreed to hear the Sackett case now. To be sure, and I've seen it happen repeatedly, the merits briefs in the Sackett have yet to be filed. There are plenty of instances when the court has granted review based upon intuition of conservative justices. The lower court ruling in favor of the environmental right was incorrect and would be reversed. But in the past, right, once they see the briefs, once they hear the argument, they realize their intuition that something wrong had happened just isn't true. And they end up affirming the lower court ruling. Did this just recently in the Maui case. They took that case to reverse, but instead they affirmed in favor of the environment. They didn't affirm, but they remanded on a test, which was a test on which environmentalists would win. I hope the justices don't just reflexively demonstrate their allegiance to Justice Scalia by converting his preponderance plurality to a majority ruling in Sackett. But having just observed the oral argument in West Virginia, I find it hard to be optimistic that we're not just going to see that plurality of Scalia now in the majority opinion, not just fingerprints, but as text, quoted again and again and again. That takes me to the last part of my talk, and that's environmental law's wrecking crew. As large as the immediate stakes in both the West Virginia and Sackett cases and they're big, the reach of EPA's authority to regulate greenhouse gas emissions, the geographic scope of the Clean Water Act, the longer-term stakes of these cases are much higher still. It is no less than the viability of federal environmental law to continue, as it has so successfully in the past 50 years, to safeguard public health and welfare through demanding environmental protection laws. As I have previously written, and I should point out, new edition coming out August 2022, it is no exaggeration that our nation's environmental protection laws that exploded to the surface in the 70s have been a great success story. They have, as deliberately designed by Congress, done no less than transformed our nation's laws, governing activities that pollute and degrade the natural environment, upon which humankind depends for its health, welfare, and enjoyment. As our economy has grown over the past 50 years exponentially, because of those tough requirements, that economic growth was not accompanied by the kind of accelerated harmful air and water pollution, natural resource degradation witnessed in other countries lacking those laws. To be sure, there are significant gaps in those laws. Environmental justice, a persistent issue of enormous import, and of course, climate change. We are in great arrears. But there's still been much success and much untapped authority in the existing laws to address both of those issues and address them well. But that is why the stakes of these cases now before the court are so great. When the overriding significance of our nation's environmental laws and the reason for their success was Congress's decision, beginning in the 1970s, to use broad, capacious statutory language to authorize expert agencies like EPA to fill in the inevitable details of environmental protection requirements. To rely on EPA's expertise, scientific, technological, and economic. To rely on agency public accountability based on the fact that Congress does confirm agency heads and political appointees are picked by a president, chosen by the national elections, and allowed to make sound decisions. And Congress can always come back and change the law if they don't like what the agencies are doing. Congress wanted, when they passed those laws, to have a legal transformation of vast economic and political significance for compelling purposes. No doubt about that. That's what Congress said at the time. When they passed the Clean Air Act, the supporters of that, Democrats and Republicans, made clear these were transformative laws. These are laws designed to make big changes in how we ran our businesses, our industry. This wasn't just technical details the EPA was going to be doing. These was deliberately broad delegations of very important authority. Under the Water Act, look at those goals, right? They seem impossible, and many were, but Congress wanted big things to happen by EPA and the Corps. Eliminate discharge of pollutants in ag waters by 1985. Right? Prohibit all discharge of toxic pollutants. These laws sought to do big things. But Congress was also well aware that it lacked itself the expertise, the practicability, the flexibility to decide all those hard questions. And they needed to be solved instead by the agency. It couldn't do that. It knew electability in the first instance, it knew electability over time to do it. And they knew they always retained the ability, as they did sometimes, to come in and override what the agency has done. But under the guise of the Scalia Court major question doctrine, a construct of the court's own invention, completely non-textual, the Scalia Court threatens, I think, to upend this highly successful form of environmental lawmaking. While claiming that it's seeking not to find elephants in mouse holes, I think they're doing the opposite. I think they're trying to take an elephant and they're trying to put it into a mouse hole. Those statutes are elephants. They're not mice. In the name of promoting democratic accountability, the least accountable branch of government, the courts, seems ready to tell Congress, the most accountable branch of government, how it must do its job. And it can't do it through broad, capacious delegation of authority. According to what I anticipate, the court's going to do the following: is to rule that Congress can delegate such authority if at all, only by specific language that makes clear Congress itself has anticipated and proved the precise manner and method of any agency's rule of great significance. This isn't a bold prediction. The court has already forecasted this result in its reasoning in the COVID OSHA cases decided just a couple months ago. Relying on the major question doctrine, in basically upending an agency rule that I think would have 15 years or 20 years ago been upheld by the court 9-0. Even when Scalia was on the court in his first 15 years, as opposed to his second 15 years. And Justice Thomas might have written a separate concurring opinion. They struck down the OSHA vaccine mask rule option based on major question doctrine, and at least three justices would have gone further and suggest that even if there was specific congressional guidance in that statute, Congress lacked the authority in the non-delegation doctrine. It wouldn't cure it. And of course, they relied for it on Justice Scalia. It's a really unsettling opinion, but unfortunately, I think that's where the court is. Whatever one thinks of such judicial rule in theory, its practical effect is clear. One can make the argument in theory, yeah, let's have Congress do all this in the first instance. But Congress, who drafted laws years ago, had no awareness. The court 50 years later would require such statutory exactitude. And Congress today lacks any possible capacity to pass laws to meet the court's, I think, need for this demanding standard. You don't have the Congress of the 1970s, which passed law after law after law after law. You don't have Congress of the 1980s, which, responding to judicial agency action, refined the laws with more and more detail and more exactitude. You don't have Congress of 1990, which passed the Clean Air Act of that law. And look at how they evolved that law. Look how Congress over time answered all the questions. You start one way, and then over time you work in a very constructive iterative process. Depending on the precise wording of the court's opinion, I think we're not going to see a Congress can meet it. The Congress today is incapable of passing comprehensive environmental legislation. They couldn't do so even after one of the nation's greatest environmental disasters, and that is, of course, the Deepwater Horizon oil spill in 2010. What did Congress pass to try to prevent future spills? Nothing. Even a national disaster led to no new laws. And of course, climate change, one of the greatest threats of our time. Has Congress been able to pass anything? No. Again, nothing is passed. Again, depending on the precision of what exactly the court requires in their theory, the degree of precision they require, the result could well be the equivalent of a judicial wrecking crew through the nation's environmental laws. A potentially disaster result prompted by the court's insistence on addressing a problem that I think doesn't even exist. Tantamount to a war on environmental law for the nation's highest court, absent any provocation at all. An ironic endgame in fulfilling the legacy of a justice who decried judicial activism. Thanks a lot. Look forward to your questions and hearing from my colleagues.
Thank you so much, Richard. Not seeing any questions in the chat, I think we'll hold discussion of Richard's presentation to the roundtable part. I do invite those of you who want to present questions going forward to enter them into the chat. But lacking any right now, I think we'll move directly on to Professor Adler's talk.
All righty. Unlike Richard, I do not have an amazing slideshow, so you're going to be kind of stuck with me, and I apologize for that in advance. It's an honor to be included in this discussion today, in these conversations with Richard, with Robin, with Robert, with Dick Pierce, and all of you. I come at these questions from a slightly different perspective, although I think some of my descriptive observations will be similar to Richard's. Perhaps some of the conclusions about where we go might be a little different and hopefully are at least a little bit more optimistic. What I want to do in my time is to suggest that both these cases are signs that this is a court that is concerned about the limits on federal regulatory authority. This has been a longstanding concern within conservative jurisprudence, and these two cases show that the court's current majority is interested in identifying, exploring, and defining and enforcing those limits. What the consequences of a court that is interested in such limits are for environmental protection, in at least some respects, depends upon how we, as environmental lawyers, as advocates of environmental conservation, respond to the existence of such limits. As I noted, this emphasis on limits is grounded in particular concerns about the nature of government power that are longstanding in contemporary conservative jurisprudence. Concerns about the scope of federal power under Article 1, Section 8, and the ability and authority of the federal government to intrude upon matters that traditionally have been left in the hands of state and local governments, as well as limits on power that Congress has or perhaps even can delegate to regulatory agencies. Richard suggested these are, in some respects, the legacy of Justice Scalia. I might differ a little bit on that point, in that I certainly think that this is a court that very much follows many of the methodological priorities of Justice Scalia, or at least attempts to. But substantively, in many respects, I think this emphasis on limits in particular is the legacy of the late Chief Justice Rehnquist. It was his opinions as an associate justice that raised particular concerns about the scope of federal regulatory power at a time when few judges or justices were concerned about such limits, and his opinions on the court that also both expressed concerns about delegation of power to federal agencies at a time when we weren't really concerned about the non-delegation doctrine. But I think that also provided the roadmap to what we might now characterize as the major questions doctrine. We can go back and look at Rehnquist's, Associate Justice Rehnquist's concurring opinion in the Hodel decision, or his majority opinions in cases like Lopez, Morrison, and Swank, Solid Waste Agency of Northern Cook County. And then in the delegation context, we can look at his opinion, his separate opinion in the benzene case, as identifying the sort of ways that delegation concerns can influence or affect statutory interpretation. As I will note going forward, these concerns about limits are grounded in constitutional concerns, but I am not sure they will be operationalized in constitutional terms. I think it is more likely they will be operationalized in terms of statutory interpretation, but the effect that there are meaningful limits both on the scope of federal regulatory authority and meaningful limits on the regulatory power that has been delegated to agencies like the EPA, those limits will be real nonetheless. Now, I should also note at the start that this focus on limits is particularly problematic for environmental law as it has been traditionally conceived and as it has been implemented and operationalized in the United States over the past 50 years. Environmental protection traditionally focuses on the fact of pervasive ecological interconnection, that everything is connected to everything else, and that this interconnection and the resulting ecological dynamism are things that require expansive regulatory authority and nimble regulatory authority. Arguments about the need to delegate power to expert administrative agencies are perhaps at their apex in the environmental context because of the irreducible complexity of environmental questions. And that creates a challenge because if we have a governmental structure that is premised upon the existence of and maintenance of certain limits on governmental authority that may be hard to reconcile with the demands of environmental protection. The environmental philosopher David Orr identified this tension as he put it, and I quote, "Nature is a unified mosaic of ecosystems, functions, and processes. Government, on the other hand, was conceived by the founders as a limited and fractured enterprise." And Orr in his work has gone on to point out that there is a fundamental mismatch between the way nature works in highly connected and interactive systems and the fragmentation of powers built into the Constitution. And certainly, if that's the way we conceive of environmental protection and the demands it places upon the legal system, there is a dramatic tension there. There might even be a fundamental incompatibility. At the end of my remarks, I want to suggest that maybe we can challenge some of those premises. Maybe we can, in fact, advance environmental protection in ways that are consistent with and build upon the existence of this limited and fractured enterprise that David Orr spoke of. But certainly to do so, that will require us, in many respects, reconceiving of the way we approach environmental protection. The way we have done it for much of the last 50 years may not be the way that we need to do it for the next 50. And I think this idea of an underlying tension encapsulates why the current court's focus on limits, on identifying limits and enforcing limits, creates a particular challenge for environmental law. So let me say a little bit about the cases and how the cases that we are dealing with bring to the fore this question of limits, and then say a little bit about how we might respond to that. So as Richard noted, one of the cases is the case of the Sacketts. Michael and Chantal Sackett are no strangers to environmental lawyers. They are no strangers to the Supreme Court, having been there before. This case is not merely the latest episode in the decades-long saga to identify the outer bounds of federal regulatory jurisdiction under the Clean Water Act. It's merely the latest episode in the Sackett's effort to build a house on some property that they own. They have been to the court before on the question of whether or not they could challenge an administrative compliance order and clarify this, whether or not, in fact, their property is subject to federal regulatory jurisdiction. Now they're before the court, they've returned to the court on a broader question of whether or not the Ninth Circuit, in upholding the EPA and Army Corps of Engineers' authority to regulate their land, whether the Ninth Circuit set forth the proper test for determining whether wetlands are waters of the United States under the Clean Water Act. Now, as phrased, the court has accepted a statutory question, a question of what authority does the Clean Water Act delegate? When the Clean Water Act delegates authority to regulate activities that affect, or that activities that result in the discharge of pollutants into waters of the United States, to what extent does that reach properties like the Sacketts? But this statutory question is infused with a more far-reaching, perhaps more ominous, certainly more fundamental question about the scope of federal regulatory authority under Article 1, Section 8 of the Constitution. Clean Water Act, as I noted, prohibits the unpermitted discharge of pollutants into navigable waters. And navigable waters under the Clean Air Act are defined as waters of the United States. So we know that the Clean Water Act reaches beyond waters that are traditionally navigable. That's certainly the way we've understood that definitional move in the statute. But there is a question of how far. We know that it's not infinite, because we know that Congress's authority to regulate activities only extends to those things which are necessary and proper to the regulation of commerce among the several states. And whether we like it or not, that's not going to be coterminous with regulatory authority over hydrological systems necessarily, or those lands and places that contain waters of various sorts. At the very least, I think we can say that Article 1, Section 8 does not reach waters, the regulation of which does not have a substantial effect on commerce among the several states, or at least that's current doctrine. In 1995, as folks may recall, the court decided a case called United States versus Lopez. It involved Alfonso Lopez, a young man who brought a gun to school as part of a gun deal. He was the courier. He was the person delivering a gun as part of an illegal gun transaction. He was prosecuted for violating the Federal Gun-Free School Zones Act. He had a firearm in a school zoning contrary to federal law. And when that case went to the Supreme Court, the court decided 5-4 in an opinion by then Chief Justice Rehnquist that the possession of a gun in or around a school was not commercial activity. Regulation of such activity could not be defended as the regulation of commerce among the several states, or even, at least as given the statute that Congress adopted, as necessary and proper to the regulation of commerce among the several states. Court also went on that in engaging in this inquiry, that courts had to be attentive to and concerned about the fact that federal authority or congressional authority should not be interpreted in such a way as to intrude upon matters that are traditionally functions of state governments. And that traditional state functions should be presumed to be protected against federal interference. In Lopez, the traditional state function was the regulation and provision of school, of secondary school and primary school, the maintenance of a safe and effective learning environment. But as environmental lawyers surely recognize, we can make a similar argument about traditional state functions when it comes to the regulation of local land use. The decision about whether or not individuals like the Sacketts can build a single family home on a given plot of land. Now, when Lopez was decided, quite a few folks recognized that there was a disconnect between this articulation of the scope of federal power that the court had identified and the scope of federal power that the EPA and Army Corps were asserting under the regulations that they had adopted back in the 1980s. The regulations that the EPA and Army Corps had adopted to operationalize the Clean Water Act were not confined to the regulation of waters or even the regulation of the discharge of pollutants that could have a substantial effect on interstate commerce or even actual effects on interstate commerce. The language in the regulations in question actually extended to waters and wetlands, the use of which could affect interstate commerce. So for the last 25 years, or more than 25 years, we've had a disconnect between the way the Supreme Court has said we should understand the outer constitutional limits of federal power and the way the EPA and Army Corps have understood their authority. Because the Supreme Court said in Lopez that to regulate activities, they needed to have a substantial effect on interstate commerce. And the EPA and Army Corps not only didn't assert the need for a substantial effect, they didn't even assert the need for an actual effect. A potential effect would be sufficient. On top of that, the EPA and Army Corps repeatedly asserted authority to reach activities that could not in any way be considered to be economic in their nature. We might think the building of a home on a small plot of land like the Sacketts wish to do is economic activity. They're going to be hiring folks to do the building. They will be engaged in all sorts of economic transactions to make that possible. It may even be the case that the reason they want to build this home is to sell it and not to make it their own personal home. But the EPA and Army Corps have never said that such economic connections are necessary for the assertion of jurisdiction, nor does the statutory language anticipate such a need for an economic element to the activity regulated. In fact, in the Federal Register, the EPA and Army Corps have acknowledged that as far as the statute is concerned and they're implementing regulations, they could regulate, these are their words, walking, bicycling, or driving a vehicle through a wetland, end quote, because such activities could result in the discharge of dredged materials. The tires on the bike could pick up and redeposit dredged material. One's shoes could pick up and redeposit dredged material. Insofar as such activities are not regulated by the EPA and Army Corps, it's as a result of administrative grace, not their understanding of the scope of their own regulatory authority, not because in their view are there any statutory or constitutional limits on their authority. Given this background, this fact that the agencies have been asserting such broad authority for so long, and that this authority is at odds with constitutional limits the court has identified, it shouldn't be a surprise that when the court had the opportunity to consider the scope of their regulatory authority, it found the agency's assertions to be a bit expansive. So in the case of Solid Waste Agency versus Northern Cook County, when that reached the Supreme Court, the court decided in an opinion by Chief Justice Rehnquist that the agency's assertion of authority over isolated waters exceeded the scope of the Clean Water Act. And what the court articulated in that opinion was that there had to be a significant nexus between a water that would be regulated and navigable waters. And it made explicit that this statutory interpretation was based in part upon a need to observe the underlying constitutional constraints, the underlying constitutional limits on the agency's regulatory authority. The significant nexus test articulated in Swank was a means of narrowing the statute to avoid an underlying constitutional problem. And in Rapanos, the controlling opinion by Justice Kennedy adopted much the same understanding. That is to say, Justice Kennedy claimed to be, in Rapanos, to be following the Swank decision and restated that one reason for adopting this narrowed construction of the Clean Water Act was to preserve its constitutionality. This move that we saw in Swank and Justice Kennedy's opinion in Rapanos is a form of clear statement rule, a move of interpreting a statute in a way to preserve its constitutionality by reading it in a way that is consistent with underlying constitutional constraints. The idea being that if Congress really wants to push the boundaries of those constitutional constraints, if it really wants to present the naked constitutional question, it should have been clear in doing so. And that the court will presume that Congress meant to enact constitutional legislation, and so it will interpret the statute in a way so as to ensure that it is preserving its underlying constitutionality. Now, what's interesting is that the Supreme Court in 1995 made clear that the Commerce Clause does have outer limits. As I noted, as many folks noted at the time, I believe Richard wrote about this at the time, I know I did, that presented a problem for the scope of federal regulation under the Clean Water Act, but neither the EPA or Army Corps seemed to have much interest in that. After the Swank decision, the Bush administration shelved its efforts to adopt new regulations that would be consistent with the limits articulated and identified in the Swank decision. And the Obama administration eventually adopted a WOTUS rule to try and provide some clarity to the scope of federal regulatory jurisdiction, but at least in my view, did not do so in a way consistent with this underlying concern for both constitutional and statutory constraints on the agency's jurisdiction. Trump administration's regulations were certainly more limited than the Obama administration's regulations. Whether they properly complied with or properly respected the statutory and constitutional constraints is in some respects a moot point, since those regulations have been withdrawn. But I think it's worth noting that the part of the background of Sackett is not merely that agencies were asserting broad authority, but they were doing so continuously and regularly for an extended period of time without showing regard for limits that the Supreme Court had identified, and leaving it to lower courts to sort that out. I also think it's relevant that in a case like Sackett, those complaining about the breadth of this regulatory authority are not mining companies, not massive corporate developers, but a couple that has one plot of land upon which they want to build a house. If you go back and read the opinions from the last time the Sacketts were at the Supreme Court was clearly impressed and concerned by the effect these regulations have on small landowners. Indeed, it's worth just noting in the prior Sackett case, one of the issues the court was looking at, the question of administrative compliance orders and whether or not they can be challenged. The court had been asked to address similar questions by large corporations. General Electric had repeatedly sought the Supreme Court to look at the legality and propriety of administrative compliance orders in the Superfund context. The court had no interest in those cases. But when the same sorts of burdens were being imposed on small landowners, the court was very interested. And the court, I think, both as a legal matter, is concerned with the fact that these agencies have not shown much concern for the constitutional constraints on their authority, but that also the agency's assertion of authority doesn't merely affect large corporations, large trade associations and the like that can take care of themselves within the regulatory process, but has effects on small landowners. And I think it reflects a view of at least some of the justices that there must be other ways to advance these conservation values than to imposing disproportionate burdens on couples like the Sacketts. So I think the court has taken this case as an opportunity to remind the EPA and Army Corps that their regulatory authority is subject to meaningful limits, and that if the agencies are not going to identify meaningful limits on the scope of their regulatory authority, the court will. That while it is certainly true that navigable waters, as defined in the Clean Water Act, extend beyond those waters that are navigable in fact, it does not extend infinitely. It does not extend to any and all places where there is water that will ultimately drain into or connect with broader hydrological systems. That there is a meaningful limit, that a significant nexus is not any nexus, but a significant one. And again, that if the agencies are not going to identify the limits on their authority, then the courts will be called upon to do so. And I think that's why the court has taken this case. The West Virginia versus EPA case is also about limits, but about a different sort of limit. This is not about the limits of federal regulatory authority, the ability to regulate land use, the ability to intrude upon areas that are traditionally in the hands of state governments. This is rather about the limits of how federal power has been allocated or delegated within the federal government. In a sense, it's not about the limits of federal regulatory power as such, but about its allocation. It's about the limits on what power Congress has delegated, more so than the power that Congress could delegate. Here again, I think there are underlying constitutional concerns that are in the background, but I think they are more in the background in the West Virginia case than they are in the Sackett case. I think in the Sackett case, it's hard to talk about what the limits are on the federal government's authority to regulate waters of the United States without thinking very carefully about what the ultimate limits are on the ability to, for example, regulate land use or to regulate non-commercial activity that may result in the discharge of a pollutant or the discharge of dredged material onto a water or wetland. In this case, there is an underlying constitutional concern that certainly some of the justices have about the outer limits of what sort of power Congress can delegate to agencies. And there is perhaps a majority on the court that believes that Congress is incapable or is not allowed to delegate a blank check to federal agencies. But the precise question at issue here doesn't really call upon the justices to have those constitutional constraints in mind when resolving the case. I think in this case, it's much easier to simply focus on the statute and think about how the statute should be interpreted in ways to identify what the limits are on the EPA's authority under the Clean Air Act to reduce emissions from the power sector. Here, though, the court is concerned about limits, and this is a case with some history and with a history that I think shows that the justices are concerned about whether the EPA has interpreted its own authority in a way that is sufficiently respectful of the statutory limits on its authority. When the Supreme Court stayed the Clean Power Plan, I think that was an indication both that a majority of justices were concerned that the EPA had exceeded the statutory limits on its own authority, but also that the EPA was regulating in a way designed to evade the limits placed on agency regulation by judicial review. It's worth remembering that just before the Supreme Court stayed the Clean Power Plan, it had decided a case called Michigan versus EPA concerning the regulation of mercury emissions from power plants. And the Supreme Court concluded that the EPA's regulation was unlawful. But after the decision, the Environmental Protection Agency noted correctly that as a practical matter, Michigan versus EPA didn't matter all that much because the prospect of regulation, the threat of regulation, had been sufficient to induce power companies to adopt the necessary controls. And if one goes back and looks at the briefs filed with the Supreme Court asking for a stay of the Clean Power Plan, they highlighted this front and center. Supreme Court, don't be a chump. The EPA in the mercury rule was able to get the benefits of regulation, even though that regulation was illegal. Your judicial review took too long, and the agency and the industry had already complied. Don't let the EPA do that again with the same industry. Don't let the EPA avoid the limits that judicial review places upon agencies' ability to impose regulatory constraints. And so I don't think it's a surprise that Clean Power Plan in Michigan versus EPA concerned regulation of the same industry, but that also here again with West Virginia versus EPA, we are again dealing with regulation of the power sector, dealing with broad assertions of EPA's regulatory authority, and the court's concern that allowing the DC Circuit's broad construction of the EPA's authority to stand would in effect greenlight broad regulation, perhaps in excess of what the Clean Air Act authorizes. And the constitutional concern in the background, the concern about how broad an agency's authority can be is certainly in the background. It certainly casts a shadow on this case, but so too does the underlying nature of our constitutional structure, which is that agencies only have that authority which has in fact been delegated to them. Agencies don't have inherent authority to regulate. Agencies wait for the legislature to delegate that power to them. So respect for that constitutional baseline in many respects requires placing the onus on the agency to demonstrate that the authority it wishes to exercise is in fact there. That it can identify in the statute language which could be reasonably understood to provide the sort of authority that the agency wishes to exercise. And that underlying constitutional notion, I think, informs the way the court will look at this case. As Richard noted, the question before this court as a initial matter is whether or not the delegation of authority to impose source-specific emission controls under Section 111 of the Clean Air Act also entails the authority to mandate broader changes within the power sector. And if so, what are the limits on the EPA's authority to extend its regulatory reach in that way? And you can see this concern with limits in the questions presented in the various cert petitions that were accepted. So just to cite to the cert petition filed by West Virginia, it posed the question as whether in 42 U.S.C. Section 7411D, an ancillary provision of the Clean Air Act, Congress constitutionally authorized the Environmental Protection Agency to issue significant rules, including those capable of reshaping the nation's electricity grids and unilaterally decarbonizing virtually any sector of the economy without any limits on what the agency can require so long as it considers cost, non-air impacts, and energy requirements. West Virginia's cert petition highlighted an interpretation of the lower court decision, of the DC Circuit's decision, that gave the EPA fairly broad authority to roam in terms of what will be encompassed within its its regulatory impositions. That yes, the EPA has to consider cost. Yes, it has to consider non-air impacts and energy requirements, but that even though we may think that sections 7411, or I just tend to say section 111 of the Clean Air Act is focused on identifying category specific or source specific regulatory controls, that EPA can go beyond that. Not merely beyond the fence line, but perhaps beyond existing ownership structure, beyond the facilities, beyond the matters that are properly within the control of those entities that are expressly subject to regulation. It's a concern about the limits within the Act. The fact that the Act as written suggests certain constraints, certain outer bounds on what the EPA is allowed to do. And I believe the majority of the court is concerned about whether or not the EPA has identified limits that are sufficiently constraining. I agree with Richard that one thing the Solicitor General tried to do was create the opportunity for soft landings in this case, such as by either finding that there was no jurisdiction, or what I thought was a more plausible way of getting a soft landing of simply vacating the DC Circuit decision and dismissing on the grounds that it was at least prudentially moot, if not jurisdictionally moot. What I don't think the EPA spent enough time focused on, the Solicitor General spent enough time focused on, is identifying what the statutory limits are, if they aren't the limits being suggested by the petitioning states and coal companies. Because the court here wants a limit. And the power system as a whole, the power grid as a whole, I don't think that's a limit that the majority of the justices believes is found in the text of the Act. And therefore, an assertion to reach, or an assertion that EPA can regulate the grid as a whole would be an assertion of authority that is not bounded or limited by the Clean Air Act's statutory text, or so I believe a majority of the court is likely to hold. I think here, as in the Sackett case, you will get a decision that's focused on the statutory language and whether or and how to read that statutory language in a way that does impose meaningful legal limits. In this respect, the major questions doctrine here will perform a similar function to the clear statement rule in the Clean Water Act context, suggesting that broad, expansive authority that the EPA has not previously exercised in this context has to be tied or tethered to the statutory text, and that if it is not something that can be tied or tethered to the statutory text, then it was not something that Congress delegated. It's a way, in effect, of imposing a soft non-delegation limit on regulatory authority. Again, because as I noted, agencies have no inherent authority. They only have that authority that has been delegated to them. And I think the court's view is, and I'm sure I disagree with, or that Robert and Richard certainly disagree with me on this as a normative matter, but that if the court if an agency wishes to pour new wine out of old bottles, it really risks exceeding the scope of the authority that was delegated. When Congress drafted Section 111, it was delegating a particular sort of authority to the EPA to address particular sorts of problems. I agree that authority can easily be applied to greenhouse gases because I think greenhouse gases are emissions from sources that are subject to regulation. I don't think that's the problem. The problem is more that the type of regulation that EPA wants to require or wants to impose here is a sort of regulation that doesn't fit clearly and cleanly in the relevant statutory text, and is also the sort of authority that when Congress has delegated it to the EPA in other contexts, it has done so separately and explicitly, as when it explicitly authorized, indeed commanded, the adoption of a cap and trade program for emissions that cause acid rain, or when it adopted other sorts of broader systematic authority. And I think that the way the court is likely to look at this question is that this is in a context in which we should see Congress and EPA's relationship as a principal-agent relationship. And just as in all other contexts, legal contexts where we have principal-agent relationships, we read the delegation of authority in light of the nature of that relationship and in light of this underlying baseline of where the authority originates, that when one applies that sort of approach here, one might conclude that EPA's authority is broad, but that it is also necessarily limited. That in a principal-agent relationship, when the agent wants to do something that was not anticipated when the principal delegated authority to the agent, and it is of significant magnitude, we expect the agent to go back to the principal to seek greater instruction and renewed or expanded authority. And I suspect that in one way or another, the court will do that here. And insofar as such a limit was not provided by the Solicitor General, the question is, what limit will the court identify of its own? This particular question has not been bumping around in the courts for as long as the question that's at issue in the Sackett case, but this underlying concern about not allowing agencies to be the judge of their own authority is something that has been a concern of this court for some time, and in particular has been a concern of Chief Justice Roberts, who perhaps not coincidentally clerked for Justice Rehnquist. Chief Justice Roberts, in quite a number of opinions, often in the Chevron context, but not exclusively, has raised concerns about agencies both having the authority to answer major questions that one would have expected the legislature to have addressed, but also has expressed concerns about agencies being the judge of their own authority, that agencies being to decide how far they get to regulate. And here I would point to the Chief Justice's dissent in a case called FCC versus Arlington, which concerned whether or not a court should provide Chevron deference to cases that involve questions of the scope of an agency's regulatory jurisdiction. Justice Scalia actually wrote the majority in that opinion. Chief Justice Roberts dissented, and the concern he identified there is, I think, the concern that will motivate a majority of the justices here. And in fact, if Chief Justice Roberts ends up writing the majority opinion in West Virginia versus EPA, I suspect we will see lots of echoes of his dissent from the Arlington case. I just want to say a little bit more because I'm eager to hear Robin's comments and then certainly our broader discussion. As I noted, both of these cases are being argued or being considered in the shadow of broader constitutional concerns, but I think they both more immediately or proximately focus on statutory questions about how broadly we interpret the delegation of authority to agencies. As such, they are soft constraints on regulatory power. They are power that Congress at least has some ability to address. Congress could clarify the precise scope of regulatory authority under the Clean Water Act. Congress could expressly regulate expressly authorize the regulation of the power sector as a broad sector and do so in ways that would certainly be far more efficient and more cost effective than source by source imposition of pollution controls as a way of addressing greenhouse gas emissions. And I share the skepticism that I'm sure the other speakers do about Congress's ability or willingness to do so. Made news this week that the Senate apparently passed legislation to make daylight savings time permanent, but it turns out it was a mistake. Many senators didn't even apparently know that unanimous consent had been asked to bypass the various procedural obstacles to the enactment of legislation. So I'm not saying that Congress is likely to act in response to these sorts of decisions, but I do think it's important to point out and remind ourselves that Congress has the authority to do so. That the effect of these sorts of decisions, the effect more broadly of a court that is concerned with limits on federal regulatory authority, not merely in terms of regulating land use or the delegation of power to agencies, but perhaps also, as we might see in the context of uncompensated regulatory takings of private property or other matters that relate to environmental protection, like say conditional spending, how much of a pinch those limits place on environmental protection does depend in part upon how Congress responds. I've argued in a lot of my scholarship that it is possible to advance environmental protection in a way that is consistent with underlying constitutional restraints on federal regulatory power. In fact, in some cases, it is possible to enhance environmental protection in ways that are consistent with such limits. Federal resources are limited. Federal government can't do everything. The federal government doesn't have the ability or the personnel to fully implement and enforce the Clean Water Act, for example. That's one of the reasons why the Army Corps and EPA rely upon the nationwide permit process to exempt a wide range, or to effectively exempt a wide range of activity. But we know that when entities have limited resources, it makes sense to prioritize the allocation of those resources to those areas that will do the most good. And in a dual federalist system where you have federal regulatory authority and state regulatory authority, focusing federal efforts on those areas where the federal government has a comparative advantage, where the federal government has a distinct interest, where we expect states to be least likely or least able to regulate themselves, is a way of maximizing the value of federal regulation. Not coincidentally, that sort of approach to federal regulation is least vulnerable to the sorts of challenges we see at issue in cases like Sackett. The federal government focusing its efforts on, for example, interstate spillovers, on interstate resources, as well as using federal spending power to enhance and augment state capacity, are ways of maximizing the federal government's influence without raising the sorts of concerns for limits that we see in these cases. We should remember that for many forms of air pollution and water pollution, we had turned the corner and trends were beginning to move in a positive direction prior to the enactment of the 1970 Clean Air Act or the 1972 Clean Water Act. And so it's not as if the federal government is the only game in town. The question is, how can the federal government be involved in controlling air and water pollution in a way that maximizes the value of its intervention while also being respectful of the sorts of limits with which the Supreme Court is concerned right now. And in the context of climate change, I would argue the federal government focusing on those things that are particularly interstate would mean a big focus on climate change. But I've certainly argued, I have a piece in the Environmental Law Reporter making the case that if the goal is achieving greenhouse gas emission reductions quickly and efficiently and effectively, administrative regulation is not the way to go. It's time consuming. It's prone to litigation. The capacity of the EPA to issue regulation after regulation after regulation is constrained by resource constraints that Congress is not likely to fix. But that there are other tools, fiscal tools in particular, which can be deployed and operationalized far more quickly, and again, without triggering the sorts of legal constraint concerns that we see at issue in these cases. I'm not claiming Congress will do these sorts of things. I'm claiming that Congress can, and that if we have a court that is interested and engaged in identifying and enforcing limits on federal regulatory authority, it is incumbent for those of us who care about environmental conservation, who care about addressing climate change, to recalibrate our focus in a way that pushes those efforts forward in ways that are consistent with those underlying constraints. Just as I think it's possible to have communities that are safe from crime in ways that respect the Constitution and other limits we place on law enforcement and criminal prosecution, just as I think we can have a country that is protected and have national security in ways that are consistent with the preservation of civil liberties, I think we can have environmental protection in a way that is consistent with and respectful of the constitutional and other constraints that our legal system has traditionally imposed upon governmental power, and that the current Supreme Court is interested in imposing on regulatory power. But that there's a lot of work to do there. And certainly in some of the work that I've done with Chris Walker, tried to explore ways of figuring out how to get Congress back in the game, because I do not want to sound Pollyannish here. I do not want to suggest that, oh, no worries, Congress will just fix everything. The current Congress probably won't, but unless we start focusing on getting Congress to do the job that it is supposed to do, make legislators legislate, make them earn the fancy pins they get to wear on their lapels, well, then we're definitely not going to solve these problems, because I think the court's interest on limits on federal regulatory power are here to stay. There are, as Richard noted, 6 justices that care about such limits. That presents a challenge for environmental protection, but I do think it's a challenge that can be met, and certainly I look forward to efforts to try and see that challenge is met. And with that, I will stop, and I look forward to questions and the conversation. Thank you.
Thank you so much, Professor Adler. We have 4 minutes if we're going to stay on schedule before Professor Craig starts. There are some questions that have been posed, some of which cut across the topics discussed by all 3 speakers, but there's one that I want to raise now from Jay Austin that's directed at Professor Adler. As Professor Adler notes, Rehnquist's hint of the constitutional avoidance canon in Swank may well suit the current justice's affinity for the major questions move. In both, judicial intuitions about what is too big or goes too far become the predicate for requiring a clear legislative statement and effectively punting the issue to Professor Lazarus's gridlock Congress. And here's the question. But what is constraining those intuitions? And can they be articulated affirmatively beyond, quote, no, not that, unquote? Jonathan, any response?
Sure. Yeah, no, I think that's a fair question. First, I'll say that the answer to that is not Scalia-esque in that it's not a bright line, right? One of the hallmarks of Justice Scalia's jurisprudence was the desire to find bright lines that he thought lower court judges would be, essentially forced to observe. There is some gray here, but one of the reasons I talked about how major questions doctrine should be understood as the public law or the administrative law application of traditional principal agent understandings, traditional understandings about the nature of agency, not agency as in federal regulatory agencies, but agency in terms of agents that have been bestowed power by principals, is that raises the sort of line drawing question that we're very familiar with throughout American law. It doesn't mean there aren't hard cases, but it also means there are hard cases, but there are also lots of easy cases. And any case which requires an answer of there's no limit is necessarily the wrong answer. In the context of federalism, we can have an interesting debate and discussion about how much of a nexus is required for it to be significant. And if one recalls Justice Kennedy's opinion in Rapanos, there's that long section at the end where, as I read it, he's essentially pleading with the agencies to use their expertise to articulate and identify all the variables that would be part of a meaningful significant nexus inquiry and could have been embodied in a new regulation. Recall also in Rapanos, Chief Justice Roberts suggesting it was a Chevron Step 2 opinion, and that the agencies could step into that breach. Unfortunately, that's not what we saw. But it's a fair point that this does not produce a clear bright line rule, but it is a recognition that authority is bounded, and that if agencies want to operate in a legally safe space, operating in a legal zone where they are relatively protected from legal and judicial challenge, they have to identify limits. And if they fail to do so, and they assert authority that is effectively unbounded in its underlying logic, as I think has been the case with the EPA and Army Corps' understanding of waters of the United States, as I think is at least one plausible interpretation of the DC Circuit opinion under review in West Virginia versus EPA, well, then that's going to be an answer that's going to be rejected. And just lastly on that point, I think this is kind of inherent in this approach. If one looks at decisions like Lopez, one doesn't see a bright line. One doesn't see a bright line other than an assertion by the majority that the lack of limits is impermissible. We can fight over what the limit is, and there may be some wiggle room there, but it has to be a meaningful one, and it may take time to explicate that. And again, I would argue that our task is then to try and focus on ways of advancing environmental protection that don't push those boundaries, and instead operate in spaces that are less likely to provoke such concerns.
Thanks so much. So the final speaker for this portion of the program is Professor Craig. Take it away, Robin.
All right, thanks, Rob. Get my slides up and going. So I'm going to be the one who dives into the weeds. Jonathan and Richard both supplied some pretty broad views of these two cases. I am going to dive into the specifics of each case and hopefully put it in a little bit of a fun context. But before I do, I do want to mention that I agree with Jonathan that Congress could. I'm not like Jonathan, I don't think it likely that Congress will, but Congress could step in, because what these cases also illustrate is one major logical flaw at the bottom of each piece of litigation. West Virginia, the flaw is that as much as I love Massachusetts versus EPA, and as much as the mobile source regulation of greenhouse gases has been going great guns, greenhouse gas regulation does not fit the stationary source provisions of the Clean Air Act all that well. UARG made that clear. The need for a tailoring rule made that clear. This is a perfect time for Congress to step in and make a better fit, or have more comprehensive legislation. So there's just that lack of fit there that makes these cases in the stationary source context a little difficult. On the Sackett side, the fundamental flaw in the Clean Water Act, in my humble opinion, is that we have two vastly different permit programs that resonate. Section 4 permit program that regulates dredging material, and the NPDES permit program that regulates pollutants into the navigable waters, that have the same trigger. And that's why you get Maui, County of Maui, as a very positive environmental case, but all of the limitations on waters of the United States have come up in the Section 404. I agree with Jonathan that they raise concern. Those cases raise concerns that the NPDES context does not. So, but like I said, I'm going to dive into the weeds, reflecting the level of confusion that we are now at, Congress being the missing player in this regulatory game. So who's on first? And yeah, I mean them, Abbott and Costello. What we are dealing with are double reversals and piecemeal participation by the courts. So we've got an Obama EPA that promulgated a regulation in both cases. We have a Trump EPA that repealed that regulation and did its own rule. We now have a Biden EPA that wants to get in the game. And along the way, courts have chosen to review some of these rules and not others. The Clean Power Plan escaped initial review, for example. And it's kind of a mess. So what does this mean in the hairy details of what might get decided? And I'm going to have 4 parts. Who's on first? So what exactly is the Supreme Court likely to be deciding? And in a pure administrative law framework, who gets the first crack at those decisions? Or part 2, is EPA likely to get deference for anything in either case? We've got new justices and new issues, so I don't know. On third is those new justices and issues that might complicate deference predictions, might complicate where we go. And the EPA is still at bat. There's ongoing rulemaking processes for both cases. So here we go. Who's on first? So just a quick review: federal court deference to agencies. Some of this will not be relevant to either case. Some of it might. But we have APA deference when the agency applies law to a particular situation. This has been relevant in the Sackett case, might still be relevant in the Sackett case. We have Chevron deference, which refers to a formal interpretation of a statute that the agency implements. Again, could be relevant in Sackett depending on what the EPA decides to do with its new rulemaking, but I doubt it. Skidmore-Mead, informal, not likely to come up in either case. And our Seminole Rock deference, when an agency interprets its own regulation, again, not likely to come up in either case. But we are very definitely playing with some of the exceptions to Chevron deference, i.e. when the court won't look to the agency's interpretation. And that includes, as Jonathan mentioned, the scope of an agency's authority under the statute. The court routinely does not allow the agencies to decide their own authority. We've got the major questions doctrine out there, and whatever the heck the major questions doctrine means, which I'll get to in a second. What the text of a statute actually is, this was a potential issue for the West Virginia case. It hasn't come up, but there are two versions of 111D out there. Has not made its way to the Supreme Court, but that would be an issue for the court. And then just to emphasize, which usually now gets wrapped into the major questions doctrine, but Swank was one of the originating cases for the idea that if an agency is pushing a constitutional boundary, we really like some pretty clear indication that Congress has given it authority. Now, personally, I think we could have avoided a lot of the problems with the Clean Water Act if the courts had just squarely addressed the limits of the Commerce Clause as it applies under the Act, but they didn't do that. Instead, they used it as a deference issue. So what do we have going on in West Virginia versus EPA? Has already been mentioned, Clean Air Act case involving the regulation of existing stationary sources of greenhouse gases. Now, I'm going to present section 111D in its full. Richard gave you the text, but he, for reasons of clarity, left out the complicated phrasing that actually exists in the statutory provision. The administrator shall provide regulations which shall establish a procedure similar to that for SIPs, state implementation plans, under which each state shall submit to the administrator a plan which establishes standards of performance for any existing source of any air pollutant for which air quality criteria have not been issued, or which is not included on a list of criteria air pollutants, or emitted from a source category which is regulated under the hazardous air pollutant provisions, but to which a new source performance standard would apply if such existing source were a new source, and provides for the implementation and enforcement of such standards of performance. Deep breath. Got that? Yeah, it's not that easy a provision, all right? It warrants some interpretation, and that's one of the issues of the case, is the Clean Power Plan was really the first time the EPA had used this provision to any great extent whatsoever, and it's not a model of clarity. It takes some good familiarity with the Clean Air Act and a little bit of time to parse this out to even take a stab at what it means, let alone what it allows. So the fact that this needs to be interpreted is probably not an issue. American Lung Association was the case before or below. Raised basically 4 issues. There were a few more we could throw in, but overall, did the Trump administration's ACE rule properly establish the best system of emission reduction for fossil fuel fired power plants? What deference does the EPA get in putting that forward? What is the best system of emission reduction? What does that actually mean? And the DC Circuit did squarely address the issue of, does the major questions doctrine apply? So on the overall question, was this a good rule? The DC Circuit indicated quite clearly it would have upheld the Clean Power Plan, the Obama administration rule. but the ACE rule insisting that it could only regulate individual sources at the source within the fence line was overturned. What deference to the EPA? The court said none, and that was because the Trump administration EPA was asserting that Congress, basically the statute was not ambiguous. The Congress compelled the regulation that it enacted. And as a result, the court said, no deference to you on that. What does the best system of emission reduction mean? A system that efficiently and effectively reduces emissions. Using that word system that is possibly going to be part of the Supreme Court's focus in the West Virginia decision. And does the major questions doctrine apply? The DC Circuit said pretty clearly, no, it doesn't. Each critical element of the agency's authority has long been recognized by Congress and judicial precedent. So we do have a direct decision on the major questions issue for the court to review. But I think it's important to note the negative framing of the statutory interpretation question as it came out of the DC Circuit. Basically, as I said, is 111D unambiguous in prohibiting the EPA from relying on electricity generation switching, or is it a little more flexible than that? Is it got some more ambiguity, so more room for the agency to maneuver? As that was phrased, as it came up in the DC Circuit, we're basically, if you want to think in terms of agency deference, we're still at Chevron step 1. Which is for the court. Is the statute ambiguous or not? And we've kind of skipped over that step at the US Supreme Court. So the certiorari question granted in West Virginia versus EPA, just to emphasize what Jonathan and Richard have already said, is whether in 42 USC section 7411D, as Jonathan said, an ancillary provision of the Clean Air Act, interesting phrasing there, Congress constitutionally authorized the Environmental Protection Agency to issue significant rules, including those capable of reshaping the nation's electricity grids and unilaterally decarbonizing virtually any sector of the economy without any limits on what the agency requires, so long as it considers cost, non-air impacts, and energy requirements, which arguably, and the federal government is so arguing, those last three are actually fairly significant limits. But nevertheless, that's the question is granted, and it does suggest that the court, or at least in granting cert, is interested in the constitutional limits that Jonathan mentioned, and in this major questions doctrine. Now, also interesting, I think, to look at the question it didn't take, which is whether the EPA may employ Section 111D to impose standards of performance on existing stationary sources that are regulated under the Hazardous Air Pollutants Program. This would have been a really easy way, if the court wanted to go there, to get rid of the existing source rules, because power plants are regulated under the hazardous pollutant provisions. One way of reading that complicated sentence I gave you in 111D is that they're therefore precluded from being regulated under 111D. That soft landing, the Supreme Court cut off from the get-go. All right, so some issues that came up in the briefs, like I said, just to get into some of the weeds. As we've already heard, do the petitioners have standing to appeal, or is the appeal moot? I agree with Jonathan. I think the mootness framing is a little bit easier for the court to get to if it chooses to do that, on the grounds that there really is no regulation in place at the moment in West Virginia. In the context of regulating greenhouse gas emissions, does 111D give the EPA that broad authority? I think that's clearly what many justices want to get to. If the EPA does have that broad authority as a statutory matter, are there constitutional federalism constraints on the EPA's authority? And if so, or otherwise, would that authority violate the non-delegation doctrine? So Jonathan's run through those last two as well as anyone could, but this is kind of how issues lined up in the briefing. Now, issues in oral argument. Again, do the petitioners have standing, or is the case moot? If so, does the major questions doctrine apply, and why? And what is the major questions doctrine exactly? So one issue I will flag as might be important in a much broader context for the opinion that might come out of West Virginia is a definition of the major questions doctrine that goes beyond anything we have heretofore seen. There were a lot of justices that seemed very interested in coming up with a more precise definition of what that doctrine is. What is a system in the context of best system of emissions reduction? Is Massachusetts versus EPA at issue? I raise it because it came up a couple times, and both times the answer was decisively no. So maybe we can breathe a sigh of relief on that one. And are costs and other constraints sufficient limitations on the EPA? So I agree with Jonathan. I think the court is looking for limitations, but as the United States argued fairly forcefully, there already are limitations in Section 111. The question will be, are those good enough? And then one more asked in a variety of phrasings multiple times, where exactly is that fence line? And does it really correlate to whether there's a major question? And I think this bolsters Richard's prediction that if we get to the major questions doctrine, it might be a little broader than in the fence line, outside the fence line, or to be a little more precise, whether the EPA can do whatever it wants in regulating a stationary source so long as it imposes requirements for the source itself, versus whether it can reach more broadly to the system of electricity generation. There were several justices on both sides of the aisle that made the point that EPA could be pretty disruptive just regulating the sources themselves, as Richard had already pointed out. And I think that's, if we get past the standing mootness issue, I think that's going to be an important part of the decision. So I agree with Richard there. So how about the details of Sackett versus EPA? Well, the nice thing about Sackett versus EPA, at least in terms of coming up with pictures, is it involves an actual place. So this is Priest Lake, which is the navigable water body at issue in Sackett. No real question from anyone that Priest Lake itself is a traditionally navigable water subject to the Clean Water Act. So that at least no one seems to be challenging. And just to run through the Clean Water Act provisions at issue again, except as the Act otherwise allows, the discharge of a pollutant is prohibited. This is the basic prohibition in the Clean Water Act. The discharge of a pollutant includes, among other things, the addition of a pollutant to the navigable waters. Because I do ocean and coastal law, I also always point out, also includes the addition of pollutant to the ocean. But the navigable waters is our key term. Navigable waters are the waters of the United States, including the territorial sea. The territorial sea has a fairly clear definition, referencing international law, among other things, but the waters of the United States is the phrase that comes up. Now, on the surface, if I was just handing this to one of my students, the Clean Water Act seems like a much easier provision to deal with than Section 111D. At least on the initial read, it certainly seems to make a lot more linguistic sense. But as both Jonathan and Richard have pointed out, we've got three major Supreme Court decisions in the background of the Sackett decision, all of which again focus on Section 404. So Riverside Bayview, 9-0, as Richard pointed out, wetlands adjacent to traditionally navigable waters are jurisdictional. Footnote, always be careful of Supreme Court footnotes. Footnotes, we're not ruling on anything else. Swank, 5-4, this is where we got our constitutional avoidance doctrine. No isolated waters are regulated under the Clean Water Act on the basis of the migratory bird rule. That is the most technical reading I can give you of that decision. It actually is broader than that, or has been interpreted to be broader than that, and was the genesis of the significant nexus test that has become key to waters of the United States. And then finally, Rapanos, that 414 decision, pick your test, direct surface water connection to traditionally navigable waters. That was Justice Scalia's opinion. Justice Kennedy's significant nexus test, or the dissent saying the test should be broader, but we've lost that. So either or, either way you want to go, we'll support. So issues below in Sackett, again, the overall issue, did the EPA properly determine that the Sackett's wetlands are subject to the Clean Water Act? Along the way, did the Trump administration's attempt to withdraw the compliance order moot the case? Was it okay for the EPA to include a wetlands ecologist post-order memo? You have to be a real administrative law geek to worry about that one, but it was in there. And did the EPA properly determine that there were wetlands on the property? So, of course, that overall decision, yes, the court said there are wetlands, they are subject to the Clean Water Act. The Ninth Circuit, which had been a little fuzzy about which Rapanos approach it was using, applied the Marx analysis and said, yeah, we're going with the significant nexus test from Rapanos, Justice Kennedy's one justice opinion. Did that attempt at withdrawing the compliance order moot the case? The court said no. It was an 11th hour 2-paragraph letter given right before they had to complete briefing in the case, and the court said, yeah, this could be undone in a heartbeat. That doesn't moot the case. Voluntary secession rule, among others. Like I said, technical issue in the administrative record, the EPA included the wetlands ecologist or memorandum that came out after the compliance order itself. Was it okay to put that in the administrative record? The court said, yeah, although the memo itself postdated the compliance order, it memorialized the site visit that was important to establishing jurisdiction. And then finally, did the EPA properly determine that there were wetlands on the property? As you'll see in a second, the property looks pretty dry these days. And the court said, yeah, the EPA had substantial evidence. There's that APA deference in the form of aerial photographs and inundation that supported the conclusion that this was wetlands, even if the native soil was now gone. So this is a picture of the property itself. Couple of things worth noting. First of all, there's Priest Lake right there, and I want you to remember how close Priest Lake is when I read you the Ninth Circuit's description of why there's a significant nexus. But really close to Priest Lake, as significant nexus opinions go, we didn't have a whole lot of distance to work with here. But also notice that there's developments all around and in front of this parcel. So to Jonathan's point that, we're worried about individual homeowners, there's a fairness argument to be made just looking at this picture. I don't like the Sacketts. I don't like their approach, but I have to say both issues they brought up do have a certain amount of appeal to them. Should you be able to challenge a compliance order right away? And hey, look at the property. There's development right in front of us. How can you say we don't get to when there's that lakefront property right there? So just pointing that out. So the Ninth Circuit in my humble opinion, complicated the significant nexus analysis. And I'm pointing this out because I suspect it might become fodder for the Supreme Court. So this was the analysis the Ninth Circuit went through. The wetlands were adjacent to an unnamed stream 30 feet away and on the other side of a road that is tributary to Kalispell Creek, which flows into Priest Lake. Like I said, nobody questioning that's a traditionally navigable water. Plus, the Sackett's wetlands are part of one of the 5 largest complexes along that 62-mile-long shoreline. And those wetlands in combination significantly affect the integrity and water quality of Priest Lake. So that's the full analysis that the Ninth Circuit went through. And this was subject to arbitrary and capricious review. So again, putting it in an administrative law context, application of the law, the significant nexus test to the facts at hand, the Ninth Circuit said, yeah, this analysis gets arbitrary and capricious review. But that deference assumes that the EPA was using the correct test, and the Sackett's proposed issue on petition for certiorari, which is not what the Supreme Court granted, was should Rapanos be revisited to adopt the pluralities test for wetlands jurisdiction under the Clean Water Act. So focusing on Rapanos itself and the desire for the pluralities test. And issues that came up in the briefs on whether cert should be granted or not, which there were a number of, raised issues like the Clean Water Act usurps state authority, so that federalism constitutional issue. The Clean Water Act is being applied inconsistently. Factually, true, it is. Significant nexus test is unconstitutionally vague. The significant nexus test violates the Commerce Clause. The Scalia-Rapanos plurality controls under Marx. Given Rapanos, the Supreme Court must exercise interpretive primacy. And I want to emphasize this one because if Sackett focuses on how to best interpret Rapanos, we're not interpreting the statute. We're interpreting a prior Supreme Court opinion, and the EPA really has nothing to say about that. My favorite one, ping pong policy making is unconstitutional and creates regulatory uncertainty. The regulatory uncertainty part is certainly true. Whether going back and forth between administrations is actually unconstitutional would be an interesting analysis. I don't think the court's going to get there. And as Richard and Jonathan have already pointed out, there's no circuit conflict on that the significant nexus test applies. The circuit split that exists after Rapanos is whether you use just the significant nexus test or you use both the Scalia and Kennedy test, but certainly no one has rejected the significant nexus test. So the rephrase question as the Supreme Court took it, whether the Ninth Circuit set forth the proper test for whether wetlands is waters of the United States. And I'm emphasizing this because it shifts the focus from what Rapanos meant to what wetlands are regulated. And I think that's significant. And I think the United States thought it was significant too, because the United States emphasized in its brief opposing cert that the district court had found that the Sackett wetlands were directly adjacent to Priest Lake, connected by a subsurface flow. So I'm thinking we might be in for a little bit more of a ride than just what to do with Rapanos. So my question is, will we be revisiting Rapanos? Probably. Or will we be revisiting Riverside Bayview? I think maybe, and probably both. So that's my gloom and doom prediction for where the Supreme Court is going on Sackett. I think that the way that the Ninth Circuit found the significant nexus is going to encourage at least some members of the court to re-look at what we mean by adjacent wetlands as well. All right, so that was the longest part. What's on second? Deference in West Virginia. My question is, okay, to what? It won't be to the ACE rule because the current EPA agrees with the DC Circuit. Probably not to the Clean Power Plan because the current EPA agreed to put it on hold. And we got nothing else at the moment to work with. So, you know, this is a pure statutory interpretation in the absence of any agency regulation on the books, which I think is the best argument for it being moot. How about in Sackett? Again, same question. Clean water protection rule. The current EPA has got no interest in defending that. The EPA should get APA deference regarding whether there are wetlands on the property. I doubt the Supreme Court will get there, but if it comes up, it should get APA deference on that. And if the court does not go with a different test, how to apply the significant nexus test, but that only works if the latter is in fact the right test. Maybe the 2022 rule, if we have a 2022 rule, but that to me will raise the question of whether in the 2022 rule, if it is a 2022 rule, the EPA is interpreting the Clean Water Act itself or interpreting the court. And I'll get to why I think that in a second. So the court itself, I'm not going to compete with Richard on this, but I will just point out I'm a little more optimistic than he is on our three newest justices. I think they have a few surprises in store for us, and I don't think we know the full range of what they might decide sitting on the bench. We do know, however, that we've got three justices that are very much into the major questions doctrine, including Gorsuch, Thomas, and Alito. Twice in the last 2 years have banded together in concurrences to emphasize that the major questions doctrine should apply. So I think we're already 3 votes in clearly to going with the major questions doctrine in West Virginia versus Sackett. How about standing? To me, this is a little more mixed picture. This is the Supreme Court standing decision since January 2nd. Even then, I didn't pick up, Justice Coney Barrett was not part of all of them. But on the whole, the decisions that actually discussed standing in the opinion, the court has said, overall, no standing in 6 of them, and yes, standing in 5 of them. But how the coalition of justices comes together varies a lot from case to case, including Justice Thomas going with the liberal end of the court on standing questions. So this is quite the mix of where we might go on standing, and I want to particularly point out Gorsuch and Kavanaugh that buck the court's trend, and Justice Roberts, who is, Gorsuch and Kavanaugh clearly on court's trend, and Roberts himself is actually the least likely to grant standing of any of the justices. So that one to me is a more open question. We'll see how it turns out. Again, I think it's easier to go with mootness in West Virginia than otherwise. But on the court's environmental decisions on the whole in the last couple of years, we've had a couple of surprises. So the decisions I think have a clear environmental versus non-environmental side. I've indicated in green and red. That we've had 3 that I find personally hard to classify one way or the other, Atlantic Richfield being one of them. What to do with Montana landowners that want to bring a state law claim that requires a greater cleanup. The court said they are PRPs under CERCLA. County of Maui was the pro Clean Water Act jurisdiction decision. interpreting the word from, allowing a broader definition of when a discharge is from a point source. As Rich has already noticed, Chief Justice Roberts authored the majority opinion. The U.S. Forest Service case was one of the weird ones. It was whether the National Park Service or the U.S. Forest Service had authority over a pipeline. The Fish and Wildlife Service decision, Sierra Club decision, saying that you couldn't use FOIA to get your hands on draft biological opinions under the Endangered Species Act. The Guam case, which by the way was authored by our potentially next Supreme Court justice at the DC Circuit, was 9-0, saying, hey, just because you had litigation under the Clean Water Act that came to a resolution doesn't mean you've triggered the statute of limitations on CERCLA. And then the Hawley Frontier case, which is another obscure provision of the Clean Air Act on extension for compliance for small refineries. The dissent author was Justice Coney Barrett. So like I said, I'm a little more optimistic. We might have a few surprises along the way, but we'll see. So for Sackett, the big question, of course, is going to be who is the 9th justice? And we have a nominee. Hearings start next week. Judge Brown Jackson has a decent environmental record, but we'll see how the hearings go. And that, of course, opens another unknown for the Sackett decision. Maybe not as complete an unknown as we might have hoped, but we'll see how that goes. So just got some uncertainties on there. And then finally, just to close out, the EPA is at bat in West Virginia versus EPA, as we sort of already heard. But again, I want to emphasize the DC Circuit vacated the Clean Power Plan repeal rule. EPA sought to stay the vacatur of the repeal rule, which is a triple negative that only lawyers can appreciate. So we've repealed a rule, we're vacating that, we're staying the vacation. So yeah, but anyway, not in effect. DC Circuit granted the motion, so saying there's be no vacatur of the repeal rule until the EPA has a new rule, which means effectively the Clean Power Plan will never go into effect. And we're waiting. The United States indicated in an oral argument that EPA intends to issue a proposed rule by the end of 2022. We'll see if that happens. In Sackett, there's currently a circuit split on how to determine WOTUS. Like I said, doesn't call into question the significant nexus test, but does disagree on whether it's an either or test or just the significant nexus test. On December 7th, 2021, EPA published its proposed new WOTUS definition. The proposed rule basically goes back to the 1980s regs, but modifies them to incorporate the significant nexus test, which means that Sackett could really matter to the validity of those regulations, because the EPA is basically interpreting Rapanos to mean that the significant nexus test is part of waters of the United States. And I'm simplifying a little, but not much. Pretty much anything that's not a traditionally navigable water or an interstate water under the new regulation becomes waters of the United States by way of that significant nexus test. So what the court says about the significant nexus test, if it gets there, could be determinative of whether this new regulation is valid or not before it gets out of the gate. So my last consideration is, why wouldn't the EPA, given that it is in rulemaking in the Clean Water Act and contemplating rulemaking under the Clean Air Act, why wouldn't it want to just wait and find out what the court's going to say? We all know the last 2 decades make eminently clear that whatever it comes up with is going to litigation. So why make the potentially new rules dead on arrival by trying to get them out before we have whatever the Supreme Court's going to say. So with that, I will say thank you and look forward to the greater discussion.
Robin, I'm going to direct one question to you before we move on to the next portion of the program.
Okay.
Since you brought up Judge Brown Jackson. So a couple of questions from one of our attendees, and you kind of addressed this, but I wanted to know if you could elaborate briefly. What is Justice Brown Jackson's environmental record, and is she likely to be confirmed?
I have given up predicting the Senate, but on the environmental record, it's generally decent. She is good with statutory complexity, not as deferential as other judges have been, but like I said, she was the author of the lower court opinion in the Guam case, and so I think, like I said, I think she's decent to good on her environmental record, and we'll see what the confirmation hearings yield. Like I said, I have given up predicting the Senate on that, but Richard probably has more insight.
Is that for me? Sure. I took a pretty quick look at her rulings. I mean, very, very quick. Not the Court of Appeals, just District Court. The Guam case, she really got vindicated on that one. I wouldn't call her opinion pro or anti-environmental. She was reversed by Judge Tatel, wrote the opinion for the DC Circuit, and one could hardly claim a better environmental pedigree than Tatel. It was really a lawyer's case, and she had the better reading of it. In terms of looking at her district court rulings, I went through pretty quickly. I thought she just seemed like a really good judge. I found a bunch of cases she ruled against environmentalists on standing grounds, sometimes ruled for them, sometimes against them. I saw cases where she ruled against them on the merits, relying on saying the agency had acted arbitrarily and capriciously. She was a pretty just judge. You'd expect the environmentalists to lose more of those cases and they win because of the deferential standard. I didn't see her just giving them standing all the time. They probably lost more often than they won in cases before her, and that's probably a reflection of some of the merits. And they won some of the cases against the Trump administration, which made a lot of mistakes. So she didn't look to me like sort of this aggressive environmental judge. She struck me as the same thing you saw with Ruth Bader Ginsburg's rulings on the DC Circuit, same things you saw with Judge Breyer's views on the First Circuit. Neither one had a record that was like pro-environmental in any way, and she seems the same.
Thank you both. So we've got about a half hour left in the main part of the program, and here's how we're going to proceed in this roundtable part. I'm going to make a few remarks first, then I'm going to let Professor Pierce make a few remarks, and then if, to the extent there's time left, we will let the speakers respond to each other and perhaps respond to audience questions. We do have, beginning at 4 o'clock, an open social room portion of the program. So to the extent that you've asked questions that don't get answered in the next half hour, if we're able to stay for that social room part, you might get answers then. If there are any questions remain that haven't been answered at any time, we'll try and provide written answers and circulate those to attendees. So I want to start with a proposition about the need for environmental law to respond to changing circumstances. And that's obvious. Many of the most important US environmental laws were enacted in direct response to dramatic events like the discovery of chemical contamination at Love Canal, New York, and the Exxon Valdez oil spill. The agencies that administer our nation's environmental laws also respond to changed circumstances and new information, including the latest developments in scientific knowledge. The federal environmental laws are strewn with delegations of authority to agencies to base their decisions on the best available scientific information. The ability of environmental policymakers to be nimble and responsive to a changing world is more important today than ever. Because of climate change, we're facing what some have referred to as a no analog future. Climate change has altered the natural environment in unprecedented ways, and those changes pose challenges for policymakers who have the responsibility under the environmental statutes to respond to them. Unfortunately, there are real questions about whether the current system of environmental law is equipped to allow the policymaking responsiveness we need. And I want to make 3 points here. First, earlier this week, Ezra Klein wrote an op-ed for the New York Times in which he discussed a lawsuit brought by an organization called Save Berkeley's Neighborhoods, led by a former investment banker, against the University of California, Berkeley. The lawsuit claimed that the university added too many students without first considering the adverse environmental effects of increasing student enrollment on the neighborhoods surrounding the Berkeley campus, including more trash and noise. The lawsuit claimed that the university violated the California Environmental Quality Act, also known as CEQA, which is the state's equivalent of the National Environmental Policy Act, or NEPA. NEPA, of course, is the federal statute whose adoption in 1970 kicked off a flurry of legislative activity that included passage of the Clean Air Act, the Clean Water Act, the Endangered Species Act, and the various other statutes that Richard Slide enumerated. NEPA was designed, as the California statute was, to be a stop and think law. It forces agencies otherwise disinclined to think about the environmental consequences of their actions, to do so before committing to those actions. Klein argues in his op-ed that in cases like the Berkeley lawsuit, CEQA and NEPA have been transformed from engines of radical reform to a status quo that was prone to run roughshod over the environment, to mechanisms that contribute to making government plodding and unresponsive. Klein is concerned not so much about the size of Berkeley's student body, but about government's ability to build green infrastructure at the speed that is necessary to minimize the worst consequences of climate change. He argues that the environmental victories of yesteryear have become obstacles to transformational projects like those needed to facilitate the movement of renewable energy from the places it's produced to the places it's needed to displace coal-fired electric power. And he cites the example of a political scientist at UC Santa Barbara whose efforts to switch from natural gas to a clean energy source at her home has been stymied by the state regulatory bureaucracy. Similarly, for those who watch HBO, Bill Maher sometimes shows his solar clock on his HBO show, which tallied the 1,131 days it took for his solar power installation to be connected to the electric power grid. Laws like CEQA and NEPA, which have done enormous good in other contexts, are not the only obstacles to the transformations we need to make the changes that are necessary in response to climate change. Another story this week, published in the Penn Program on Regulations Regulatory Review, discusses a referendum passed in Maine last November. Voters overwhelmingly rejected the construction of a transmission line that would have brought clean, renewable energy from Canada to England, not wanting the line to be built in their backyard. Environmental law scholars like Alex Klass and Uma Autka have argued that state authority over the siting of energy infrastructure has blocked efforts to green the nation's electric grid. What does all this have to do to West Virginia and Sackett cases? I'm afraid that the Supreme Court's resolution of these and other cases involving the exercise of agency regulatory authority will further shackle the ability of policymakers to act nimbly and effectively in response to the environmental challenges presented to them. And here I'm going to pick up on Jonathan's brief reference to efforts to pour new wine from old bottles. The version of the major questions doctrine that seems to be emerging is, to me, incredibly problematic. That version provides, as we've heard, that if an agency seeks to exercise its regulatory authority in ways that create significant economic and social consequences, courts should deny that authority unless the statute clearly and specifically provides it. Efforts by Congress and statutes like the Clean Air Act to delegate broadly worded authority to enable an agency to respond to unforeseen challenges would not suffice. Worse yet, some members of the court seem to be of the view that if an agency relies on an old statute to regulate in ways it hasn't tried before, that effort should be struck down as ultra vires. The court, as Richard pointed out, has used that rationale to invalidate the Biden administration's moratorium on tenant evictions that could exacerbate the risks of spread of COVID, and its vaccine or testing mandate on large private employers. And the court invalidated the vaccine or testing mandate despite authorization in OSHA's statute that gives OSHA the power to protect employees from grave dangers arising from new hazards. Not good enough, the court said. But the reason an agency like OSHA has never tried to respond to a pandemic by requiring vaccinations or testing, or why EPA for years didn't attempt to tackle climate change is obvious. Those conditions were unprecedented. Neither agency had faced or been called on to address that particular set of challenges before. The need for flexibility and rapid government response is arguably most acute when it faces novel challenges like a viral pandemic in an age when travel is much more widespread than it was in 1918, or an unprecedented rise in sea levels caused by melting glaciers that pose risks of large-scale coastal flooding. The response of the proponents of this version of the major questions doctrine is, don't worry, the doctrine doesn't prevent government action, it just shifts the responsibility to respond to Congress, which has the authority to specifically authorize agencies to address these kinds of challenges. But congressional gridlock, as we've heard, makes that argument fanciful. Congress hasn't amended the Clean Air Act or the Clean Water Act in more than 30 years. So the arm of government that in theory could act, won't, and the arm of government best situated to be responsive is deemed powerless to do so. My ultimate conclusion is that the major questions doctrine, as it seems to be emerging, is just one more nail in the coffin of government responsiveness. It's a pernicious anti-regulatory doctrine that punishes innovation and creativity when it's most needed and provides a prescription for dysfunctional government. And I'll end there and turn it over to Dick.
Okay, so let me take a crack at that one in several ways. First of all, your reference to the action that kept California, University of California, from enrolling all of the students that it wanted to this coming semester is an interesting one, and it is instructive because yesterday the California legislature overruled that by an overwhelming vote. So it turns out if an agency does something that is really stupid, the legislature will respond by telling it can't do it. The university, the Cal Berkeley now has a complete green light from the legislature to enroll all the students that it wanted to enroll. Now, your reference to the jurisdictional issue with respect to approval of siting and construction of transmission lines is also instructive. That is a function of the Federal Power Act of 1938. Okay, since 1938, that has been the law. It isn't questionable. It's absolutely clear law. It is stupid. It became astonishingly stupid about 25 or 30 years ago when most transactions in the electricity industry began to cross state lines. And so the idea of saying, well, any state can block any other state from getting clean electricity, in this case, from the source, is just stupid and irresponsible, as Alice Klaas has been arguing for 15 years now. Congress won't do a damn thing about it, nothing whatsoever. The administration, this administration is well aware of that problem, didn't even propose any changes in law that would affect that. Now, I agree with you that is reflective of a very sick legislature. That concerns me a whole heck of a lot. I don't know what to say about that characteristic of the legislature, except I don't think we can survive as a constitutional democracy unless we can return to the times when Congress would regularly sit down and engage in the compromises necessary to enact bipartisan legislation. I don't think that can happen until after we change our methods of choosing candidates from office. We abandon party-based candidates, primaries, that always have the effect of nominating the most extreme radicals on both the right and the left, and replace them with open primaries that will allow a lot more moderate candidates to be nominated and to get into office, and those candidates, those members of Congress will then be much more likely to sit down and actually to communicate with one another in an effort to compromise and come up with legislation. Now, unfortunately, I don't think that is the problem in the case of the big problem of how to address climate change, because the big problem there is the people will not support the spending of their money to accomplish that purpose. Every public opinion poll now shows that a majority of people want to see action taken, and more action taken, to address the problem of climate change. And I'd love to see that happen. But as you know, every one of those public opinion polls, as soon as you ask them, are you willing to spend a nickel to do it? You lose too many of them. And in the event that any president had any doubt about that, you know, we had Barack Obama at the beginning of his first term, when he had a majority of Democrats in both the House and the Senate, proposing what would have been a quite effective means of addressing climate change. By the time it got through one house, which took months, it had been weakened to the point where it probably wouldn't have had any beneficial effect. And the other house wasn't even willing to consider it. So even when the Democrats control the White House, the House, and the Senate, that they will not act. Then when Biden comes into office, he doesn't propose anything that would be at all effective. He proposes a couple of little pieces of the Build Back Better Act that would have been massive corporate giveaways with very little beneficial effect. And he couldn't even get those passed. And the reason is pretty simple. The public will not spend money to do this. And anytime any politician has doubt about that, all he has to do is look around the world and see things like when Macron took some actions that had the effect of increasing the price of energy just a little bit. All of a sudden, he confronted mass demonstrations by the yellow-shirted gang all over the country. After 18 months, he finally concluded that he had to back down completely. He rescinded those actions and capitulated when he realized that the yellow vests were destroying the economy of France. And then you look at Kazakhstan, where again, the leader of the country took an action that had the effect of increasing the cost of energy just a little bit. And he discovered that the only way he could stay in office was by calling his buddy Vladimir Putin in Moscow and asking him to send some units of the Russian army in to protect him from the mobs that were trying to kill him and take over the government, because they did not want to see an increase in the price of energy. And he had any doubt about that. All that President Biden has to do is look at what has happened to his favorables since the cost of energy has gone up. And he just can't seem to budge above the 41% favorable mark now. And I predict that unless and until he can get the energy price back down to about what it was when he took office, he's toast. And so is the Democratic Party. So that's the problem there. It's not even a problem. It's not a problem in the court. I don't like the major questions doctrine. I don't like a lot of the things that the six conservative justices are doing, and they can be blamed for a lot of problems. I don't like the inability of Congress to engage in any effective legislative action, but neither of those are the source of the problem when it comes to mitigation of climate change. We are the source of that problem. We, the people, and what we call democracy. We don't want to pay more money. And mitigation of climate change is damned expensive because wind and solar are intermittent sources, and we do not have an inexpensive method of storing bulk supplies of electricity that would allow anybody to get reliable electricity service dependent entirely upon intermittent sources of energy.
Thank you, Professor Pierce. Everybody has referred at some point to the major questions doctrine. And there's a question from Rhonda Ruff that I'm going to kind of paraphrase and throw it out for anybody. She's essentially saying that the major questions doctrine narrows the scope of statutory authority when agencies want to do something by way of regulation, but seems to ignore the major impact of inaction. And the question is, well, she says she's shocked at how unfamiliar the justices are on the potential impacts of inaction when it comes to climate change. Can we request that the justices be briefed on the recent IPCC report? Any responses to that pair of questions?
I think it would be cool to brief them on the IPCC, but to put it in the context of the major questions doctrine, I think one of the things that has gotten lost with that doctrine is in two of the cases where it was originally invoked, Brown and Williamson, which involved the FDA's decision to suddenly regulate cigarettes as drugs under the Food, Drug, and Cosmetic Act. And even in Swank, there was another text outside the statute against which to compare the agency's authority. So tobacco is regulated. It's regulated a whole bunch of different ways under other federal statutes. And that was part of the court's reasoning in Brown and Williamson of, hey, there's this whole other body of law that deals with tobacco, deals with it in a specific way. We don't think that just because it technically fits the definition of drug that Congress meant to give you the authority. And even in Swank, we've got a whole history of Commerce Clause jurisprudence to say, now whether you agree with the agency was coming up close on the limits of the Commerce Clause or not, different issue, but at least there was another text out there, set of texts out there against which to measure was this, for lack of a better word, a rational thing for the agency to be doing. What disturbs me in a lot of the recent environmental cases, particularly those involving the Clean Air Act, is the court has been interpreting silence, complete and utter silence, and it is says so explicitly. It's like, we got nothing. There's nothing. And that's particularly true with climate change. We got nothing outside of the Clean Air Act. And that to me is a much thornier way to approach statutory interpretation in general, because silence is context specific. Silence, as we all know, can be deafening, and silence can just be silence. We didn't think about it, which would seem to fall into a delegation to an agency. So that to me is the most disturbing part, and that's why I will be really interested to see if the court tries to define how and when to apply the major questions doctrine, because interpreting statutory silence has got to be context specific. And to pick up on Richard's original point of this is the Scalia Court, in my humble opinion, that was what Scalia was most famous for, was ignoring context. So I'll leave it to my other two compatriots to follow up.
Jonathan, do you want to say something? I do, but why don't you go ahead?
I mean, so I'll say a couple of things. First of all, the baseline is an agency doesn't have any authority unless Congress delegated it. So in many respects, a silence is a failure to have delegated authority. The doctrine in that respect does put a thumb on the scales, but it puts on a thumb on the scales that reinforces the underlying baseline that is built into the structure of the Constitution. There may be contexts where that baseline, as a policy matter, frustrates the ability to do things you want to do, but our constitutional structure is one that, at the very least, embodies legislative supremacy. We can have a separate debate about whether or not there are limits on what Congress can delegate, but certainly Congress must have delegated in the first place. That said, there are cases that we could understand as major questions cases in which agency authority was ultimately reaffirmed. I've argued that Massachusetts versus EPA in some respects is a major questions case because the court refuses to rely upon Chevron deference. The court's view was this is such a big issue, it is between us and the statute, and we are going to look at the statute and determine what the statute says. And the court in Massachusetts versus EPA ultimately concludes that greenhouse gases are air pollutants for under the Clean Air Act. Similarly, King versus Burwell, written by the Chief Justice, the court says we're not going to defer at all. We don't have any interest in what the IRS says. We are going to look at the statute. We are going to make sense of the statute. It is up to us to understand what Congress did or did not delegate. So there certainly are cases where the agency can be taken out of the picture by the major questions doctrine in a way that supports agency authority. And if you have administrations like the Trump administration, where agencies are inclined to assert very narrow interpretations of their own authority at times at odds with the underlying statutory text, a major questions view on when Chevron is appropriate will actually cut against an agency's ability to abdicate authority that has been properly delegated. But, you know, to go back to kind of where I began, I do think it is fair to say that, you know, yes, in a system in which agencies have no inherent authority, we do have to find an underlying source, and congressional failure to address congressional silence will be, in fact, just that. To borrow the title of an old article I co-authored years ago, the rest is silence. And yes.
So I would certainly accept Jonathan's premise, which is, you know, our federal agencies don't have general police power authority. They have to get it from Congress. I don't see silence, though. I don't see silence in the Air Act. I don't see silence in the Water Act. I see broad, capacious delegation of authority, and I see a court inventing something called the major question doctrine to say that's not a good enough. My view is the right way to do these things, and it's somewhat suggested by what Dick said in his response to something that Rob said, and what the court did with the Rivers and Harbors Act 1899, the Organic Act of 1897. You look at the language, and there it is. I think it's perfectly fair to interpret system to refer. They've used a word they don't generally use, system, and it's a broad, capacious word. And EPA, I think, is in its discretion to take it to mean what it now means in our current context. And they do that. And if they get it wrong, right? If it turns out the here and now, which is always more powerful than the there and then, and environmental protection laws are always addressing the interests of the there and then at the cost of the there and then for the cost of the here and now. And so what you do is if you instead say, okay, agencies have that authority, Congress passed that language, don't worry about the here and now. They'll get themselves heard. They'll get themselves heard before Congress, just like the Berkeley was managed to get itself heard, obviously, in the California legislature. You change the default. And if the default is in favor of reading the broad and capacious language as it is, then we'll get a legislative debate. And then you'll actually see legislation, because the here and now will need it. They'll need it in a response. And of course, that's why we got the Clean Air Act of 1970. It was because California started to regulate automobiles. And the auto industry said, we need national legislation. And so then there was the leverage to get really good legislation. It's why we got the Water Pollution Control Act in 1972, because the Rivers and Harbors Act, Refuse Act, had made all those industrial discharges unlawful. And so who needed legislation? Guess who did? Industry, the here and now needed legislation. What did we get? Really good legislation. Why? Because then they needed legislation, and during the legislative process, you can get compromises made. But unless the sort of here and now, the powerful interests are the ones who need the legislation, they'll always stop it. Because it's very hard to get legislation passed. If the court were to uphold EPA's authority here and to say EPA could, guess what? I bet we'd have some climate legislation for the first time in 30 years. If they were to uphold EPA's authority for a very broad construction of the Clean Water Act, guess what? I bet we'd have some amendments. but they'd be amendments which wouldn't just be one-sided, because the party that wants the Congress to act, that needs an act, they're the ones who have to compromise, because it's very easy to stop legislation. So the problem with the major question doctrine is it completely changed the default principle. It makes it so the environmental interests are always the one who need legislation, and they're never going to get it, because they represent the there and then. You've got to have the default principle be one. Once you have not silenced broad, capacious language, as Congress has chosen, you want the default principle to be in favor of the agency if it wants to, democratically elected by a president appointed. If they want to have it to take care of the there and then, great. Then we'll get some congressional action. This current thing is a complete stalemate. I agree with Dick. Dick also made a really good point, which is, even the Democrats can't get this stuff passed. I mean, there was Obama in 2009. And that's why if you look at most of the walls of environmental law professors, like mine over here, you see a dent in the wall. And that's because that's where environmental law professors have been hitting their heads over the past 20 or 30 years, because we've seen climate coming and we know how hard it is to address, and nothing's harder than climate. But so I can't say it would happen, but I at least want to give it a chance to happen. And I think the major question doctrine will interfere with that.
If I could jump in there, just what I mean, none of us is happy with the extent to which Congress does or does not act, but I do think we sometimes overstate it. I mean, if we look, for example, just in the period 2019, 2020, major funding for drinking water systems, arguably the largest conservation bill in the nation's history was enacted, criminal justice reform. These are big things. And, Congress passed them. They didn't get a lot of attention. There was just a postal reform bill that was enacted. So Congress can act. It doesn't act as much as we would like. I think there were two things that Richard said that I think are worth highlighting. One is the party that wants action needs to compromise. I think that's true. We can imagine what that compromise would look like in the context of climate. How many folks that are constantly saying we need climate legislation, I'm not saying on this call, but I'm saying among political folks that various activist groups and the like are putting any such compromises on the table? I think it's a fair question to ask. Second thing Richard pointed out, which I think is the more interesting one, about the history of the Clean Water Act. In this paper that I did with Chris Walker, we have a hypothetical scenario that is worth thinking about. Let's, all the major, or almost all of the major federal environmental statutes are technically expired in that they were not reauthorized. What if it were understood that a consequence of expired reauthorization was that EPA could not issue a permit that protects a source from a citizen suit? It's not clear to me that that's actually not actually the right legal result. The reason I identify that is that there are ways we might be able to think about how Congress itself can create the incentives or the structures that require Congress to revisit some of these statutes. I'm not saying that Chris Walker and I had the right answer to that. I'm saying that that's a very, in the environmental context in particular, I think it's a very fruitful area of scholarship and inquiry. Just as Congress figured out to get trade agreements, you need to structure the process in a particular way. Congressional Review Act, how do you structure the process in a particular way to accelerate the repeal of regulations? Are there ways to understand the way statutes operate so that Congress would have to revisit them more regularly? And similarly related to that, as I understand the rules, and I invite correction on this, you need effectively unanimous consent to appropriate money to operate an unauthorized program or a program for which the authorization has expired. Right? Are there ways to, with Clean Air Act, Clean Water Act, whatever else, say, look, there's got to be a deal because we're not going to allow business as usual? There might be, and I think that could recreate the dynamic that Richard described was so important to the Clean Water Act of 1972, where you kind of had this old, clumsy, old, very painful hammer and no way to stop it from hitting without coming to the table and making a deal. And I would encourage, scholars that are on their this and so on, students that are looking for student note ideas, There are a lot of interesting ideas in this space that are worth investigating that might uncover ways of forcing Congress to do its job.
I think we're just about out of time. Robin, did you want to add something?
Yeah, I agree with Jonathan that it is a fruitful way to a fruitful line of investigation, although I will point out as a potential counterexample the National Flood Insurance Program, which does force reauthorization and has been unable to get it for longer than a few months at a time since 2017. That's got other things going on. I admit that, but I think proving that in areas of complex regulation, there's no silver bullet ever. So.
We're out of time, but I would just point out that at least several of your comments responded to Professor Victor Flatt's question about whether the panelists could express the most optimistic view that Congress can still legislate. Professor Pierce said it's going to depend upon the way in which political parties operate and the legislative process operates. That could help. And Professors Lazarus and Adler said we need to manipulate the default rules, either through legislation or through judicial decision, in ways that create incentives for parties that want legislation to intervene in the process and press for legislation. I want to thank all the speakers for a terrific job this afternoon. This was a great session. I learned a lot. I hope others did too. Thanking all of our speakers for a terrific set of presentations today.